The main trial was that there was an application moved by CBI to take on record certain documents. And before this, we had come before this honorable court had said that you deal with this application and thereafter deal with my discharge. The trial court in the impugn order has taken on record those two documents which have been impugned and also said that they will go ahead with framing of charge. So unless
You will be heard on the question of framing of charges. What is the lead to?
Yes,
You give the memo, we'll see.
but my discharge is not pending, so.
It's all right, give the memo. Not one day. When the petition was filed? When have you filed the petition?
This is after notice.
When have you filed the petition?
Well, this was filed in June.
And overnight, Monday.
No, the matter was posted on.
Had some respect to the system. And it is a matter of discharge. You will not be hanged.
No, it's.
If it is charge is friend, you can file a petition out. Yes. Next.
So this is a criminal appeal of the year 2018. The Vigilance Department is the opposite party. So Lordship might recollect this matter relates to that matter where the medical officer died. Since he was terminated from service because of the conviction, obviously wife and children were suffering. Lordship may recollect.
Criminality, this is the same story.
Yes, my lords, I know. But there was a judicial order specifically that 7/11/2024 it was supposed to be listed. It has been delisted, my lords.
At least with the memo, it will be included in the list.
So let's
Yes.
That was CLMC 1279 of 2021. Court already released all of evidence. It's not sequence schedule considering the proceeding.
Because the court have been granted bail, so therefore you want.
That's same matter.
Give the memo, it will come in serial.
I didn't mention matter. Restitution CRLMC matter matter. Challenging the order of cognizance in a DV case. The present CRLMC has been filed.
Give memo, it will come in serial. Not no urgency.
husband and wife both enter into compromise.
Compromise. 498A. Okay. So that next week. Yes.
My lord, three press admission matters. One matter is the marriage has been resolved between the husband and wife.
Is it a matter settled? Already settled?
Already settled.
Matrimonial dispute.
Matrimonial dispute. Another two matters press admission.
Press admission don't mention any coming serial. Serial it will come, you need not keep the memo. It will come serial.
So far as this matter, CRLMC number 389 of 2024.
It's all right, but it will come serial. I will not jump the list. Okay.
Pardon to mention item 2, let me take care of 1 week after.
Item 2. Not 1 week after, but it will go to December.
Item 67.
December. Yes.
Item 67 permitted to withdraw.
67 that matter on that matter my lord. Item 67
Matter. That matter means hundreds of matter.
lady appeared and told that it has not been settled, my lord.
Yes, what to do?
I am permitted to withdraw with the liberty to file a better application because there is some points.
Yes.
I have to
67. Huh? Without liberty to file
better application.
Appearance में
appearance. Yes.
opposite
Both accounts.
Item 5 now, but item 5. I have to file which asset properly. So, I will file which asset properly.
It will come in December. Thank you.
Next,
It will come in December.
I will look at the June
1 week before vacation. Yes.
item number 69. Only by asset applicable.
No. Why have you not filed?
Because
See, people are mentioning standing in queue. Your matter is listed. You ask me for adjournment. What is this? No. Don't explain, please. Just see the line.
June
Whatever. When you come.
Item 69.
In this case, there is a possible settlement in the current document.
Possible or settlement?
I am for the opposite party.
For the
What is the offense?
376 matter is compromise.
Also.
Good date fix of both the party affair.
No, that's right, but problem is also there.
Yes.
What is the age of the child? Oh, well,
The major.
become major. Then
Marriage settle है. Date खाली date full.
what is the terms of settlement you tell?
Sir marriage हमारा chance.
Chance.
Date fix.
Marriage, after marriage you come.
नहीं already हमें compromise है.
Don't use the judicial process to force someone to marry.
नहीं sir खाली appearance में lots of date.
Give a date. Let us give a date, we'll see.
There is entry order also.
Yes.
Item 26, compromise
Yes.
matter, my lord, may be
Yes.
taken up to my lord.
Yes.
Pardon your lordship, out of list mention your lordship. Your lordship, it's a CLMC matter for questioning of the FIR and the charge sheet, your lordship. Your lordship, the offence was committed in the year 2018. However, the offence, the charges has been leveled under the PC Act of 1988 instead of,
What do you want?
I want the listing of the matter.
It will be listed. Serially it will come. Yes.
Obliged, your lordship.
Yes.
With your lordship's permission, will
Yes.
item number 77 in today's list.
Yes.
It's a vigilance matter, my lords. If your lordship will remember, this relates, my lords, to charge sheet having been filed against certain subordinate administrative service officers
Yes.
with relation to irregularities caused during the recruitment at Bolangir to posts of amins and inspectors, my lords. One matter has been heard by your lordship before the vacation, and it is reserved for judgment. And these two are of the co-accused persons in item 77. The co-accused persons revisions are here. On the last occasion when the matters were tagged together, learned Vigilance Council made a mention that these matters should be de-tagged from the other matter because there was a difference between those matters. The only difference is petitioner in that case the number. He was only checking the Oriya news.
So what do you want now?
Plus, that matter is pending judgment, my lords. So therefore, whether the vigilance will do it or not, that's why I made a mention. I don't see the Vigilance Council.
Whose petition judgment is reserved, it seems. That's what he
That
says.
is Criminal Revision 584 of 2020.
Huh?
Other party person, including the beneficiary applicant, that has been dismissed by this one. In CRLMC, if it is my knowledge, senior is mentioned.
77.
Division. Mr.
Secretary, okay, we'll see. Yes.
My lord, small prayer, my lord. My lord, small prayer, my lord. Item 130 in the entire weekly list.
Yes.
That yesterday my learning senior, Mr. Das, vigilance has made mention. Then later on I also discussed him, he had some difficulty. So yesterday he could not even present. We have already discussed matter. That was 24th at 2 p.m. Because of the cyclone Dana declaration 24th day. What do you mean? That he has also said me, if you can take it out on 7th at 2 p.m.
See, system.
Yes.
I'm just, I in a particular manner. Not that you are convenient, I was present. You have not said that midnight.
My lord, I was present all through of the day. Yesterday I was present entire day.
That's right, but you have to be fair to the court.
My lord, yes,
You have to understand.
Fair, your lordship. I will inform my learning senior. We will together make an answer on 7th.
That's right. That's better idea.
That is exactly.
Right. So that let it come on that day. You mention it morning, we take it up.
It is there, my lord.
And today what happened? See, today he was telling me matter is fixed at 2 o'clock, 2:30, 2:45, all these things.
80 matters are there and some hearing matters are there.
So that's not possible. You say fixed at 2 o'clock, but how difficult it is for the client,
My lord, since it is there for entire week, I will inform my learning senior on 7th.
Let ready come so that whenever free, I will take it up.
On 7th, my lord, we will make a mention.
Yes.
7th.
When it was dismissed?
Well, already that is beyond.
When? 23, my lord. 23, my lord. So it will come in serially. Yes. Pardon me, weekly list item 133. CBI appeal trap, appeal my lord. I want to take care of any day for a query. It is there in the weekly. You get ready once I am ready. Once the miscellaneous board is exhausted, I'll take it up. Any day. No, it's there. Today is also possible. Get ready. After 3 o'clock you come, be there. I can take up. Yes.
I will be item 42 minutes. Remove it, one, that is to be one head.
What do you want?
Present case comes 171 by 24, another 175. How many put him at the not? Any day.
Both the matters list somewhat.
175 and
Yes.
24.
List both the matters together. Yes, one. Item 1. Yes.
Item paper and adjournment. Paper and adjournment.
Item 1 adjourn. Why?
Also difficult. The senior lordship is supposed to. Wherein we have challenged the order wherein 143A of NI Act has been passed without assigning any reasons there. But no order has been passed.
Last order, 5/9/2024 order. Let's see what have we written. 2 lines. What is the meaning of this? It is made clear that the pendency of the petitioner shall not renewed to the benefit of the petitioner seeking adjournment from the trial. What is the meaning of this? Renewed and the trial. Who is this order? Right now. 5/9/2024. No, the last date there was a. I said something written, something else is written. It is written, it is made clear that the pendency of the petitioner shall not be renewed to the benefit of the petitioner seeking adjournment from the trial. And renewed. Annual, I said annual to the benefit of the petitioner. It is written renewed to the benefit of it. And the two lines order I have signed it. Therefore, I was telling you. Change it. Annual to the benefit of the petitioner. Yes, what do you? Adjournment. Adjourn on the request.
You answer the opposite party. Directly, then you go back to the contract.
You proceed, there is no stay. Yes. You proceed. December. On request of the petitioner, you proceed.
Right.
Published.
Item C.
I have challenged the order dated 27/6/2022 at page 11, my lord. Cognizance was taken against the informant and the present petitioner, both an advocate, filed case each other. The lordship flag V, charge sheet, last occasion your lordship directed, I filed the charge sheet.
Yes.
Flag V, your lordship.
Flag V, yes.
I have filed in court.
Give a copy.
Yes, I'll sure.
I'll put it next week or so. Give a copy.
Yes.
Give a copy, just check it up. Yes.
No, both are advocates. Charge sheet submitted 506, my lord. When they are standing nearby SDGM court, my lord, there is a push and pull, thereafter FIR lodge against each other. All are,
just check it up. If you can give a copy of the charge sheet, yes, right now, I'll pass it over.
Pass it over, I will supply the copy.
Just check.
Detail going.
Let us.
No, total.
Tomorrow. Also.
Okay.
For the day tomorrow.
Give it.
Right.
Not tomorrow. Let you on Friday. Friday. Okay. Both 3 and 4.
Total line. Total.
This is
Another. No. Petition was saying, another case. How will this case?
this gentleman lawyer has.
Now, your lordship kindly post 8, your lordship kindly see. He has given, as per FIR allegation, my lord, your lordship, page 8, para 12. Your lordship, money received which has received. Money has been received in the year 2017 in the safe of money received 2016, my lord. Absolutely false case, my lord.
No, see, no, there may be a typo.
That is the charge sheet. Flag B, your lordship. I have supplied the charge sheet copy.
You are a lawyer.
Yeah. No, again.
All this thing.
What happened, my lord? He has taken money, my lord. When he did not return, my lord, I have approached. Thereafter, this case has been filed.
No, read the allegation.
Allegation, my lord.
Para on 16/10/2020.
ମୁଁ ଜ୍ୟୋତ୍ସ୍ନାମୟୀ ରାଉତ ସୁଆଂଶ ଯେ ଲଳିତ ମୋହନ ମନ୍ଦରାଜ ପିତା ସୁଆଂଶ 28/2/2017 ତାରିଖରେ ତାଙ୍କ ମନି ରିସିଭ୍ ନମ୍ବର 5/10/2016 ତାରିଖରେ ଦେଇ ମୋ ଠାରୁ ନଗଦ 1 ଲକ୍ଷ ଟଙ୍କା ତା 28/2/2017 ତାରିଖରେ ମୋର ଆନ୍ଧ୍ରା ବ୍ୟାଙ୍କ ଚେକ୍ ନମ୍ବର ସୁଆଂଶ 2 ଲକ୍ଷ ଟଙ୍କା ଏଇଭଳି ସର୍ବମୋଟ 3 ଲକ୍ଷ ଟଙ୍କା ନେଇ ମତେ ହଳଦିଆ ପଦରରେ ଶୁଭମ ବିହାରଠାରେ ହଳଦିଆ ପଦର ଫ୍ଲାଟ ରେଜିଷ୍ଟ୍ରେସନ କରିଦେବାକୁ ପ୍ରତିଶ୍ରୁତି ଦେଇଥିଲେ କିନ୍ତୁ ଦୁଃଖର ଘଟଣା ଏଇକି ଯେ ଉକ୍ତ ତାରିଖ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଦୌଡାଇ ମତେ
You have also taken check. Bank transaction is there.
he has taken a car, my lord.
Only my sorted out in trial. I don't know.
Your lordship, for the case diary, visualize my lord.
No.
2016 money receipt
Check you have taken. Only one line you have picked up from the entire FIR. You have taken the check and promised to.
in my
And this is I brought convenience stage.
cognizant stage re hi
Convenience stage there are evidence against you.
let them praise for obedience. Yes, I have made her party.
Where is that? Where are they?
But they are
Bring them. Bring him.
नहीं हमें डाकिला यहाँ से कोर्ट में नोटिस नहीं जाती हो पार्टी माइनर भी but you have them active माइनर
No, that's right. But you have not made out a case for interference.
आगे 16 मसीहार ସେଇଟା ଆଜ୍ଞା exactly
One line, one date is there. On that basis, I have to cross.
like let them appear my lord your lordship issue notice let them appear.
You want that court should be a party for
most
court settlement.
ସେଇଟା ଆଜ୍ଞା କହୁନି
That is what is ultimately your
advocate my lord he has taken money.
first matter I am interfering. What kind of advocate you are? How many cases you have against you? You very fact that you are
ସେଇଟା ଆଜ୍ଞା
reflects your character. You reflects your character.
हाँ नहीं practice
It reflects your character. That's
let them notice
you argue all these things at this stage of
made a party man. Let them appear, my lord.
bring a mic.
Sort out in the problem, my lord. Here,
It's very unfair for
ମୁଁ ନହେଲେ କିଛି ପଇସା ଦେଇଦେବି ଆଜ୍ଞା ସରିଯିବ କେସଟା ସେଟଲମେଣ୍ଟ
subject to depositing 2 lakh. I need to notice.
1 lakh.
No, check you have taken 2 lakh.
1 lakh rupees.
Check. Just show me. Check. 2 lakh. Check, na? Check amount. How much?
2 lakhs check, 1 lakh.
You subject to depositing 2 lakh. Check amount. I will issue notice.
1 lakh kilos.
No. At least 138 matter will go.
1 lakh. ସେଇଟା ହେଲେ ଆଜ୍ଞା
Try to be
ହେଇଗଲେ
fair. Issue notice to the opposite party number 2 subject to petitioner and 2 lakh before this court.
1 lakh rupees.
There is no question of negotiation. You have taken 2 lakh, pay by check. And that receipt and all, I understand. There may be some,
Yes.
but check and at least you pay. What kind of lawyer you are? You are taking money, you are fighting with other people. 2 cases today only.
Again.
And you say that you are lost. Whatever.
Till that date, no court.
Stay further proceeding.
Yes.
Further proceeding.
In case number 1761 of 23.
Subject to petitioner depositing 2 lakh rupees.
Check by way of check.
By way of before this court. The money to be deposited by the petitioner shall be invested in a fixed deposit. Fixed deposit. Interest bearing fixed. It will not be disbursed. Interest bearing fixed deposit will be invested in play.
Yes.
Then if then I will send it to mediation. And that money will go and everything.
ସେଇଟା ଆଗେ decide ହେଲା ପରେ
Interest bearing fixed deposit will be invested. You deposit? Yes.
obliged.
6.
Please, your lords. I am there.
Present virtually.
Yes.
My lords, here the petitioners are aggrieved by annexure 1.
Yes.
An order of the learned magistrate issuing warrants against them, my lords. Page 8, my lords.
Yes.
Lords, facts are like this. These 4 petitioners before your lordship and 2 others, my lords, they are all accused in GR case number 1053 of 2008. Now, this GR case, my lords, was registered against these petitioners and others on an allegation of an occurrence that happened on 24/11/2008. During investigation, one of the co-accused was arrested, my lords. He has been granted bail and he is on bail. When charge sheet was filed against these petitioners and another, my lords, along with the other co-accused under 147, 148, 302.
She NBW is issued and you go and appear and set aside.
My respectful submission is this. This court has stayed further proceedings, my lords, in the connected criminal revision.
Where is that number?
That is connected matter has come.
Second sub-item, my lord.
657 of 2009.
657.
If my lords will look at the earlier order passed in the CRLMC, that is order dated 26/2024, it will be clear, my lords.
Yes. 2024, huh?
20th of June, my lords, the order dated 20th of June passed in the CRLMC.
Yes. On pages of the record, it appears that the CRLMC is integrally connected with the so and consequently which is not submitted that we issued earlier has been stated by the coordinate bench of this court. The one of the however, the transfer of the case to new court. A new court has again issued and in such matter we see that as yes.
My problem, my lords, is that the criminal revision having been tagged, it cannot be listed before the appropriate court.
Let us concentrate on revision.
What I am submitting is this, my lords.
Yes.
If your lordship will dispose of the 482 application, stating that in view of the stay orders that are continuing in the criminal revision, the NBW's issued was improper. And if your lordship quashes that, asking the court below to await the disposal of the criminal revision.
No, but the court should be let us concentrate in the revision. If the revision is, I will satisfied this NBW.
Yes.
Let the revision. The 2009 we change everything.
I can do that.
Let us argue on the revision petition. What is this matter is about? That matter, they stay.
I don't hold power in the revision petition. And if your lordship will hear the revision petition, I have nothing to say. But is it assigned to your lordship, my lord? I don't know whether it is assigned to your lordship.
Who is the revision?
This criminal revision is not assigned to your lordship's roster, my lords. Your lordship's roster is limited to revisions arising out of vigilance cases and CBI cases.
No, the revision is also there with us. Huh?
That is only vigilance and CBI, my lords. The roster.
What to do?
That is why I am saying your lordship can dispose of the CRS.
2009, the regional court has stayed the proceeding.
Yes, my lord.
Now the transport and NBW is issued. So what to do? The NBW has to be quashed simply.
Yes, that has to be quashed. If your lordship quashes the NBW and asks the trial court to await the hearing of the revision, then I will ensure that the revision is got listed and disposed.
Criminal division perhaps prayer is to stay the execution, the NBW.
That's the problem. 2009, this matter is pending. You people are not taking interest. You people are not taking interest in getting the matter listed, disposed of. Despite there is a stay, the trial court is issuing NBW because it is transferred.
Perhaps NBW will stay in that case.
But whatever, now again NBW is issued. Therefore, he has filed this petition. It has to be quashed. It has to be quashed. Then why don't you take steps for getting the revision disposed of? 2009, it is pending.
Because it has been tagged with the CRLMC, it cannot be listed. So if your lordship will dispose of the CRLMC, I assure your lordship I will get it listed.
Right, of the matter was taken up for hearing on, to make sure this is absolutely and the following order was passed. Today, along with the present petition, the criminal revision number 657 of 2009 is also listed. However, this the revision is not assigned to this court. Hence, the same is detailed to be listed before the assigned bench. Insofar as the present petition is concerned, the petitioner is agreed by the order dated 18/1/2024, whereby NBW has been issued, despite the fact that there is a stay operating. There is a stay operating.
Day of further proceedings.
Passed in the criminal revision operating. Yeah. Was in operation. Mr. Hon'Ble and counsel for the petitioner submits that the NBW issued by the court below on 18/1/2024 is liable to be quashed and quashed. He further submits that he would make endeavor to get the revision listed and be heard on merit. Regarding that to the aforementioned, the impugn order dated 18/1/2024 passed by the JMFC Gondia in GR case number 1053 of 2008 is set aside. Only set aside what to do?
No, sir. Your lordship is exercising powers under 482. So the NBW has to be quashed, my lords.
That's what I'm saying. I'm setting aside the NBW and I can't ask you to go and appear because that revision, the proceeding is state.
No, my lords. What I am submitting is that your lordship has set aside that NBW. Your lordship may ask the trial court to await the hearing of the final orders from the CRL revision.
I will not say anything. I will simply set aside and leave it there.
One line in observed since the NBW stayed in that case, ma'am.
Set aside. I have written that. Because see, the problem is once you set aside the NBW, ideally one date should be fixed so that the accused person will go and appear before the court. But today the situation is already state. Why should they go and appear?
Other proceeding for stay, only the imbue will use it.
No, that if your lordship directs, they can appear, but no coercive processes.
The petitioner shall appear before the trial court on or before 30th of November and refer to the remedy available to them under law. And apply the court regarding the pendency of the revision petition before this court. Yes.
Urgent copy, my lords.
Urgent copy. Yes.
And direction may be issued to the registrar to take steps for listing of the rule.
That I have said. You sit for the appropriate assigned batch.
Yes.
Revision. Yes. Next, please, my lord. Yes, my lord. The complaint cause of the petition, my lord, complaint case under 138 NA Act, my lord. That has been dismissed on default, my lord, and the accused has acquitted by invoking section 256 of CRPC. That order has been challenged before the revisional court, my lord. Revisional courts also confirmed that order, my lord. Where is that order of the trial court? Trial court order, my lord, 37. Yes, my lord. That is on page 9. The complainant is or is counsel told to this court is found that the complainant petition you have not cured because you didn't go what to do. Here, my lord, kindly see what happened, my lord. So now, my lord, turn to page 13. I will issue notice 138, my lord. Here, my lord, no notice was issued to the accused, my lord. So what 256, my lord, cannot be invoked, my lord. Let us see 138 matter. I will issue notice. My lord, your lordship may issue notice, but kindly for a moment, my lord, kindly see why I can't set aside without hearing the other side. In any case, notice. Because my submission, because I understand it. I understand. Before issuing notice to the accused, my lord, let us see, what is the check amount? Check amount is, my lord, 3 lakhs, my lord. Let us issue notice for us. And finally, another thing is, my lord, the trial court has posted the matter to some other date. Subsequently, it was scored and another date was in fixed. That has also, my lord, lordship may kindly see page 13, my lord. For a moment, my lord. Yes. Page 13, my lord. I am with you, my lord. I am with you. So I am issuing notice. Let us file the process and getting. Yes, sir.
Item 8.
Page 9. Item 9 also same, my lord. 9 also. Same day. 9 also. 7 and 9. Yes. Okay. 8 2. Yes. 8 2.
The petitioner challenges the order dated 24/5/2024 passed by the Learned Presiding Officer designated court, paid Kotak lordships. And here is my lord, the offence is under section 420 and 34 IPC. Petitioner is in custody of lordships 13/11/2017 lordship. He is more than the maximum period is lordships 7 years lordship. And now he is
436 capital A.
Yes, yes. For 36A, your lordships. I'll wish applications and already he has in custody more about 6 years, 11 months and 22 days.
That is for bail only.
And as per direction of the honorable court, your lordship,
I know, you are asking for bail.
yes, sir.
You are asking for bail, so why have you filed 482 then?
Your lordship, the honorable high court is due to non-compliance of the honorable high court's order. Till today, he is in custody. Your lordship,
That is non-compliant. He may file modification.
Forget about all technical. 1 minute. Forget about all technical. One minute. Forget about all technicality. 436 capital A says that 50% beyond sentence he said out, he is entitled for bail. Entitled for bail at least. He is asking for bail, that's all. Nothing else. He moved an application, it was rejected, he filed a 482 petition. Forget about technicality, whether he should have filed a bail application, whatever. The fact remains, he is already there in the custody for beyond the period. As contemplated under 436 capital A.
36.
Not all the. Yes, sir, that is. You tell me your OPID is 436 is not applicable to OPID.
It is serious economy offense, it is serious offense. It has to be dealt with separately.
Surendra Antil also says that. Surendra Antil also says that. Surendra Antil also says that. Then you tell me whether
applicable ULRCs as per 436A, as per the provision which then I am also question due to non-commission of the casualty as imposed by this ongoing court, which has not been complied by the petitioners and which is called custody, more than maximum period of 6 years, 11 months, 30 days. And as per provision of ULRC, kindly have next ULRC.
do you have the petition with you?
No, I have taken from.
1 minute, 1 minute, sir. Let him.
He has to file the modification there in their itself.
Why are you sending here and there? It's a matter of liberty. When let us understand, forget about the technicality. If he is entitled, we will give it here. If he is not entitled, it's a different story. If he is entitled, forget about the technicality.
36 will not be applicable.
Then you say you are entitled to say that. You must satisfy me. Don't bring a reason should have been filed. This should file. The liberty is involved. 482 is he is involved. Exercise and give it.
Since I am not understand. This one has been imposed in the application. That is to be debited by this coordinate match.
Where is that condition? Where is
Condition CLRC, kindly see annex ownership. 11 ownership. 19.
Where is that order?
Yes, I'm giving short of CLRC. 15/5/2019, page 4. Page 4, para 4.
Page 4, para 4. Where is that order, sir?
Order is ULRC for certified copy available to you. I am giving ULRC.
You should have filed. That is the main document.
Yes, yes. ULRC.
Yes.
15/5/2009, the Honorable Court, the ULRC passed an order and directed the petitioner to release on bail and
10,23,000.
with 5 lakhs. But two modification was also filed, which was also modified to extending now to 2 lakhs. Due to 2 lakhs, we would not pay.
And by this time you are already in custody for about
6 years, 11 months and 22 days. Around 7 years is going on.
Just see. It's very hard case. He filed twice modification. It is modified to lastly modified to 2 lakhs. He is not able to pay that 2 lakhs also. He is already there in custody for such a long time. How many years you will pay? What makes you come tomorrow? I'll allow it.
Tomorrow I have to start the instruction.
Day after Friday.
Whether he is in custody or not.
I have the 5 this application.
How many cases you have?
5 cases will also 5 cases. 1 case will also 5 cases will also 5 cases.
All the cases you are
All the cases are same past and also for 2 times of modification is there. But
all the cases you have paid
near about 8 lakhs. So near about 5 cases, near about 8 lakhs. But people are able to satisfy this order of the
only one matter. What about the other matter?
other matter is pending with ULRC. So 5 cases numbers are
You give the number of all the 5 cases. We list it next week.
Now I am giving this number to ULRC.
Give in writing, sir. Give in writing. List up next week. All the matters. Same story in all the matters. You are in custody.
Custody.
How much you can pay?
So I am today.
And you are in custody in all the matters for how many years?
How many years? Same 7 years. Near about 7 years. Next week, next week Next week,
Sorry?
Next week, I will not available.
1 week thereafter. All the matters I will take up. Because one after another, there is no point. all the matter and just see. Glasses are taken tomorrow, Friday or tomorrow. He has to take except the 5 kg here.
In which case you are.
Especially people, committing counsel with Jerusalem.
19, yes. All 5 matters. 19, yes. Seek instruction, 7 years he is already undergone. I'll release on bail.
The problem will be, once an order is there, bail order is there, it has to be modified by that court.
No, he has asked.
If the lordship will grant bail, that will amounts to.
No, I will not grant bail. I'll say that he is entitled to force at 36 capital. Because I'll tell you, he has gone for modification thrice. And it is now modified to 2 lakhs in all the matters. He is not able to pay that. If you this technicality will keep on showing, he will run around this court, that court, and another 2 months he will be engaged.
Then I will show for 36.
I will simply allow 436 and 482 I will exercise and release him bail. Don't make him suffer. 7 years he has already undergone. Even if he convicted, his sentence is served out.
What do you talk?
That's right, but what to do? This is the law.
But subsequently,
And if he had that money, that kind of money, he would have paid by now. 7 years he has suffered. What to do? These are not the recovery proceedings. No, what to do, you tell me. You can't keep him for all the things to come. That's the reality, ground reality. So you think over it and tell me, assist me so that I can.
Yes, also sort for sir. 18 days, 20 years.
20th. Okay, 20th.
You give all this, yes, copy of all the 5 applications, give it to give him, otherwise again it will be urgent. Yes. Dates duita copy days. Government to the dates plus days outside the outside the okay.
Yes. Yes.
And in this case, the petitioner is working as an executive officer at NEC Manjanagar, and he's challenging the order of cognizance which was taken against him without want of sanction.
What is the allegation?
Well, the allegation is under section 354.
What is the 354B is official duty.
No, my lord. Admittedly, my lord, it does not come on.
Outraging modesty of a woman is official duty in needs sanction.
All right. Definitely, my lord, the statute also says that there is no want of sanction in the sexually related offences. But my lord, the catch in this case is that another case which came before your lordship the other day, CRMC 2028, your lordship considering the position of his job, decided to issue notice for a compromise. Then
she must be your colleague.
Yes, ma'am. My lord, the allegations completely arose because
how many cases, how many colleagues you have harassed?
2, my lord.
2. You have a very good character. You shouldn't be there in the office itself. How many women employees are there? Must be 2 only.
Well, the other one is a male employee.
I issue notice, let us see. He lose his job unnecessary. And the allegations are 354 and
yeah. But I said the best of compromise, but
I'll simply issue notice. I'm not seeing any. Yes, issue notice and tag with that the letter.
Yes, ma'am. CRMC 2028 of 2024.
We'll see. We'll send to mediation or something.
Yep.
Yes.
2028 by 2024.
Yes.
Yes.
May I plead, my lord?
Without notice to tomorrow.
Yes, ma'am.
Yes.
Item 12, my lord.
Yes.
I'm seeking liberty to kindly withdraw this matter, my lord, because the prayer portion is filed for quashing the FIR, whereas the charge sheet has already been filed now.
Yes.
So kindly may be given the liberty to file a better application.
Then counsel for the petitioner seeks to withdraw the petition to file a fresh one on the changing circumstances. This will be granted. Yes.
30.
May belongs.
This will find the question of criminal proceeding lordship. The initial FIR has been lodged against the petitioner. 294, 323, 341, 354, 379, 506, and 34 IPC.
Yes.
And petitioner and the informant, both of the family members are in a civil dispute. The case has been registered.
Yes.
And let's say, can you see the page, annexed 2 at page 13?
You settled the issue.
Yes, let's see. The matter has been settled between both the parties, let's see.
Issue notice.
Yes, let's see.
Issue notice. Yes.
40.
The petitioner does not want to close this application.
Sorry?
Petitioner does not want to close this application.
Not this. Not this. Yes.
50.
Give a memo. Give a memo. Yes.
Might please, your lordship. My lord, the petitioners are there before your lordship making a prayer for quashing of the proceeding that has been initiated against us, against them, your lordship. Your lordship may kindly see the petitioner number 1, Subhalakshmi Panda and her husband, Hon'Ble Padi. Both are petitioners, accused persons in GR case number 253.
Wife and husband.
Husband, my lord, husband, wife and husband.
Yes. Who is Kailash Sahu?
My lord,
Kailash Chandra Sahu?
Kailash Chandra Sahu is appointment number 2, informant in my case.
Okay.
What has happened, your lordship? I am not reading the file, I am only submitting, my lord. Annexed 1, the affair says in August 8, that is his allegation, Kailash Chandra allegation, that on 8th of August, Subhalakshmi Panda threatened him. I am working as a data entry operator in MKCG Medical. But Kailash Chandra Sahu is working as a senior storekeeper. He was in the rank of now head clerk now. His allegation is that on 8th of August, I threatened him with dire consequences and vulgar language.
You mean Subhalakshmi?
Subhalakshmi Panda. And I called my husband who joined me also in threatening. For that, 2 months after, on 10th of on 8th, 10 2023, 2 months thereafter, he lost the affair. Making allegation that on 8, you will also kindly see only that part. That is page 16.
You assaulted also?
No.
323.
That is I am submitting, my lord. Page 16. On 8 2023, this allegation happened. 18 2023, affair lost. The reason, my lord. Annex 2 says that on 22/9/2023, I lost affair against him, making a long allegation of 354, 354A, 294, 286. I missed two. It is a role of that. This matter was reported to internal committee, your lordship, prevention of sexual harassment, to that committee. That committee reported that this man is a dubious character man and he was previously involved in such type of cases. He was transferred to different posts. Where only
as a counterblast to this affair,
my lord. That your lordship, I only rely upon one point. That is, I am not required to
issue notice. I'll issue notice. Issue notice, and it is what says investigation is going on.
No, say charge sheet cognizance has been taken. My appearance is there. We have not appeared. I only pray, my lord, because of this in Bhajanlal versus State of Haryana versus Bhajanlal.
I'm with you,
my lord.
I'm issuing notice, and you appear for the proceeding in the state. But you have to appear. Appear. The offences are bailable offences.
ଆମେ ବି ଜାଣିନୁ ଆଜ୍ଞା ପଇସା ଆମକୁ ବେଲ୍ 41 କରିକି ଚାର୍ଜ ସିଟ୍ ଦେଇଛନ୍ତି that even we do not know 41 ମାନେ ସେଟା ବି ଆମେ ଜାଣିନୁ that even we do not I have stated in this evidence petition ମୁଁ ଥାନାକୁ ଡକେଇଲେ
issue notice returnable so and so date the further proceeding arising out of the Baidyanathpur PS case number 533 of 2023 is stayed. However, the petitioner shall appear before the trial court and resort to the remedy available to him under law. Okay. Once you appear, then further proceeding is stayed.
If my lord has stayed already the proceeding, so let the notice be taken. Let him come, my lord.
What do you say? See, the lady files a exhaustive complaint against this complainant in this present case. 354 under all. Visakha procedure was taken up. Thereafter, as a counterblast, he files this FIR. It apparently from record. So, I'm just staying it and only as per the CORAM, further proceeding is stayed and for the proceeding states, please the matter on subject. My lord. But you file the requisites by tomorrow. By tomorrow. If the requisites is not filed by tomorrow, the interim order will stand vacated automatically. Good luck.
68.
This is against the order of revision for releasing the seized gun, my lord. In fact, the allegation against me, one Sandeep, that he has taken the licensed gun from me and was showing in a marriage party. He has taken me from photography purpose and it was shown publicly in a marriage party. So gun was seized, that boy was arrested. So I am the owner of the gun.
What the trial court says?
Trial court says that it is required for purpose of investigation.
As and when required, you will have to produce out.
That is, I have undertaken before.
Yes, madam.
Below.
What do you say?
I am the license.
He is the license holder of a gun. He has given it to his friend, according to me, for photograph purpose. He took it to a marriage party and fired. A case is registered. Whatever. The case is registered against that man. He is not the accused. He moved up for 57 for release of that. The court has rejected it. He says that I am the license holder, I am entitled, but he has given it to someone. The consequence will be followed, but why to retain that? As and when required, he will produce. Undertaking.
Because the license gun has been given.
You want to just go to
the date
next week?
Fix a date. I don't think any objection.
Just check it up. Just check it up. Okay. Is there any impediment? Legal impediment? You just tell me. Otherwise, I think he is in.
Have there been legal impediment?
Are you involved in any case?
No, Lord. I am a security in the armed sector. Also, I knew the
Yes.
In the armed sector also said there are some, just to verify.
He is not an accused.
I am not the accused.
He is not an accused.
Accused is someone
license holder and the security guard. His livelihood is affected.
Friday.
Friday. Yes.
Friday you are also fixing.
17.
The offense under section 506 is not made out, my lord. So there is that offense as per the 506 is not made out intentionally. Was arrested and accused to the petitioner on the offense of 506.
What is the stage? Investigation is on.
Investigation is going on, my lord. 506 is not made out as per the.
Let it be investigated. Not made out. They may file. They not file charge sheet.
My lord, preliminary stage ko idhar.
Only charge sheet. Only FIR is. The investigation is still going on. How do you know 506 is made out or not?
I am apprehending that I will be arrested.
Apprehension. If you are apprehending something, only anticipatory bail is available under the procedure. On the basis of apprehension, it can't be passed.
506.
Apprehension jurisdiction is 430.
And 506.
Where in the entire CRPC, apprehension jurisdiction. On the basis of apprehension, some order is to be passed. Except 438.
I have raised this question before the.
This is not apprehension jurisdiction.
But advise me that
you tell all this thing to the IO.
482 you can also.
No. 482 not at this stage. If there are procedures.
But 506 is not made out as per the FIR, kindly having last one.
Police will look into it. Not at this stage.
Direction by the issue.
No. I will simply say that whatever you want to say, tell to the police and police will take care of. The petitioner is taking for the FIR. On the ground that from the bare perusal of the allegation made in the FIR, the offense under section 506 IPC is not made out. So investigation is still going on. And the petition is based on based on mere sheer apprehension. I'm not inclined to entertain this petition. However, liberty is granted to the petitioner to apprise his granted to the petitioner to raise all the issues, to apprise his apprehension to the investigating officer, who shall deal with the same in accordance with the law. With this liberty, petition is disposed of. Yes. Next.
18.
May I please, Lordship? Lordship, my prayer is to quash the name of petitioner from the affair. The plain paper affair was lodged by the IAC of Rastal case received information from the reliable source that a group of persons numbering 5 to 8 have been assembled at Kharabulia jungle area substituted to prepare the docaity. But as for the information of the other 4 and 2 witnesses arrived at the spot, police team chased 3 of them, but others are fled away from the spot. On the basis of only the arrested persons, my name was tagged with this affair and my vehicle was seized from my home. My prayer is to cast my name from the affair. And
Madam, investigation is still going on.
Yes, sir.
It is very threshold stage. You tell all this thing to the police will take care of it. What can be done? I don't know. In the charge sheet, you may be dropped also. Charge sheet will not be filed against you if nothing is there. I'll just give that same order for the same order for the. You will apprise everything to the police will yes.
19.
Item 19, Lordship. The petitioner challenging the order of cognizance and issuance of imbue. But my limited grievance is, Lordship, in the event of my surrender, my application may be issued on Lordship 5/12/23.
5/12/23. You are on bail?
No, Lordship. My application may be considered as with other cases. In view of order,
you should you are absconding.
Not sir. Showing him abscond. Showing as absconder and MW.
Charge sheet petition is accused in FIR number. After investigation, charge sheet was filed in 1/10/2023, showing the petitioner. How many petitioners are there?
One petitioner.
The petitioner as an absconder. Therefore, by the impugn order dated 5/12/2023, MBW company that is the petitioner.
Another coordinate bench has passed and
MBW has been issued against the petitioner. Petitioner on the instruction from the client submits that he will be appearing before the court, appearing or surrendering before court on or before 30th of September and seek remedy available to him under law. What do you want to say?
Also, parity principle of parity may be taken. Coordinate bench has passed an order for another co-accused person.
They are granted bail. For the petitioner further submit that.
First or second rank.
Co-accused, no first or second. What is first or second?
That order has been passed in that way.
But I don't pass.
Same the disposal and principle of parity to be taken.
First hour, second hour,
That is not it.
Co-accused persons have already been enlarged on bail. So therefore he seeks parity with the co-accused persons. The petitioner is at liberty to move appropriate application for grant of bail on the ground on all the grounds, including the ground of query.
That's it.
20.
Last time I was directed me to file a copy of the charge sheet, but I have filed.
Yes.
It's a case. 164 a call for it last year.
Sure.
164.9, but on the ground of settlement between the parties, I have filed. My lord, last time directed me to file a copy of the charge sheet so that my lord would somehow.
376B.
376. I must be affair. That's why my lord directed me, my lord.
That's come to that.
Your lordship is also directed to confirm the CD and the CD is
there?
No, my lord, CD is not come.
Let's see. Let CD come, huh? Awaiting CD.
The last time party was there, that's why my lord has directed load past.
Issue notice to the informant also. Issue notice to the informant also. Opposite party number 2, call for the CD, leave the matters.
Sorted.
And the sorted. 1 week after. 1 week after, yes.
21.
Item 21 related to the transfer value kindly. Little transfer value.
Password.
22.
No, madam, I am there in 21.
No.
Yes. Here in this case, the petitioner who appeared for the recruitment, Hon'Ble, he has submitted employment exchange document. There, as per their advertisement, employment registration must be there. But the petitioner employment exchange registration was not valid at the point of recruitment application. So what he has done, he has applied fresh for him, but that is in January 2023. But they received it by 30th December 2022. And what he edited is, he submitted the same. He is ultimately selected. But because of the solution of this document, edited that valid in 30th December 2022, FIR has been restored. The Supreme Court in several cases, this employment exchange is not mandatory. But he has a registration number. Why registration certificate was not available? And for that purpose, FIR has been lost. And so he has not been given a time. Subsequently,
but why have you manipulated the document?
Because that
whether it is required is not required. Offense is the manipulation of the document.
21 his registration certificate was valid.
But why have you manipulated document admittedly?
Because he thought that he didn't selected
that is not.
Because during he did not do
that is the crime. That is not be mandatory. If it is not mandatory, not mandatory. But why have you manipulated document to receive the selection committee?
He has given the renewal application. But in that renewal registration,
I understood it, what you say.
Yes.
But the offense is
future perspective, but it is not a such serious crime. And the solution also,
you got the bail? You won't be getting a job now that you
were selected in several recruitment, but because of this
you already missed the train. Train has already gone.
You also
what to do.
Client doing that charge sheet, they themselves mentioned he don't have any criminal antecedent.
That's right. That those are for bail. You got the bail or not?
No, bail he has got. After he was taken into custody, and he got the regular bail.
That's the problem.
But he has also no criminal antecedent at all. Young boy.
I understand, sir. Criminal antecedent and all that will help you for the purpose of getting bail only. But how? How will you wash out these evidences which has come?
He will only change the date and year.
That is 468. That is 468.
He is having any intention, future perspective, looking at the young guy is getting selected in every.
What way I can help you? You tell me, because the evidence is living large with record. That's the problem. I have all sympathy, but
when in a case of Allahabad High Court Division Bench, they have given yes in the application, they have given yes registration certificate. On that ground, their candidature was rejected. False information they have given. And single judge dismissed their case. In Division Bench, holding several judgments of the Honorable Apex Court, said that it is not the essential eligibility criteria. So they should not be decided of getting this employment. And here something different. Well, what it is correct, but here it is criminal. Employment, because this is you rather in the where you should fight it out so that if you get some relief, it has a bearing there in this case. If you can get that job, have you filed any writ petition? That 2022 agreement he left filed any case. But, this is what best could be done, you tell me. Yes. But on the sympathy ground, I can't cross it. And try to find out any judgment or otherwise, see, this is only cognizance is taken, no? Yes. You filed a discharge application. No, I will not consider. Discharge application, I am giving you liberty. If you use discharge application, you are all the points which you have taken will be considered and disposed of by a speaking order. At least you get a complete hearing. Let me take a chance that you find out some judgment on this point 3 weeks there. Yes. And further proceeding, maybe no, I am not inclined. File an adjournment application. No, I am not inclined at all. I am not inclined at all. Rather, better is I will give full liberty to you. I will direct the trial court to pass a speaking order on your application. You do a specific application for discharge. And I give a direction to the trial court to deal with it and pass a speaking order. And thereafter also you can come. At least you will have the benefit of a speaking order. Whatever you are going to argue, those things will be reflected in that order. You will have a better audience in the High Court. That is a better idea. For my satisfaction, let me take a chance that we find out some judgments, particularly on this. You get the advantage of having a full order from the trial court. I will give a specific direction that the point which you are going to raise, all these things has to be dealt with and a speaking order should be passed. To that extent, I will say. I will not simply dismiss with the liberty to file. I will direct the trial court to pass a speaking order on your application for discharge. That's a better idea. That's a better idea. You at least get a judgment. Right. Harley, legal counsel for the petitioner seeks to withdraw this petition to move an application for discharge before the court below, raising all the points raised in this present petition and besides other point on merits, other pointed merits. The petition is disposed of with a liberty to the petitioner to move a specific application inter alia, raising all the points raised in this petition as well as the other points available to him under law. If such application is moved, the trial court is directed to deal with all the points specifically and pass a reason order. With this observation, the petition is dismissed. As early as possible, reason order as expeditiously as possible. Yes.
22.
Make please allowed. My lord, in this case, allowed Mr. Mitra appeared, but his legs because of heavy schedule, I am conducting this matter. What happened, my lord? In this matter? In this matter, my lord, if I are registered under section 379,
you want passing for the
no, my lord. I am challenging the revisional order. What happened, my lord? If I are registered 379, 429, 34 of IPC, removed section 7 of Odisha Prevention of Cow Slaughter Act. In that matter, my lord, a skin of the bovines and boots, hides, all were seized, my lord. And during pendency of investigation, the OPQ and 3, the claimant filed 457 application before the SDJ.
Yes.
JNFC Bhadrak. That application disclosed, my lord. Thereafter, they moved to the revisional court. Without considering the procedural aspect and also the further the investigation is going on and the PCA and audit provisions, he passed an order for release of the scheme shell auction. That is at page number. Is that what? Page number 30. Release of seized articles, 1,300 pieces of salted raw bovine hides.
What is that? What is that?
Page number 30, my lord.
Yes. Yes. 30. Yes.
Whereas, my lord, in our state,
30.
30, my lord.
Yes.
Whereas in our state, my lord, the total prevention is there, my lord. total bovine cow slaughter. There is no single slaughterhouse in our state. Then how to get the bovine?
We are the intervener.
I am the intervener before the exhibition. Thereafter, I am the OP in the revision petition. Now I am the petitioner here, Lord.
What do you say?
The Lordship kindly turn to page 28. The finding of the law and court below. Keeping in view the opportunity principle of law, it is crystal clear that the seizure article so and so have been made from the possession of the petitioner number 1 and 2. Seized article are not required for the purpose of investigation as is apparent from the report of the IA. In this case, seized the salted raw bovine hide, WS goat, sheep skin and salted raw bovine hide are subject to natural decay. From the date of seizure till today, about 46 days have already been lapsed, and there is no allegation of theft in respect of seized article. The counsel for the petitioners has also produced two purchase receipts showing the purchase of the seized article in the name of Hindustan International, that the company is situated at Kolkata, West Bengal. Therefore, on going through the aforesaid evidence, it cannot be said that the repealed order passed by the learned court below withstand the test of legality, propriety and correctness. When the articles have been seized, who are you?
Mr. Shaw, who are you?
I am objecting that I am one of the informant in this matter, Lordship. I am the intervener before the SDJ. Thereafter, the learned session was made me as a OPP, and thereafter I prefer this application, my lord. I am coming to page number 55. What they are saying, my lord? The order of the learned JLFC, my lord. So far as the handwritten money receipts are concerned, they are doubtful and have no authenticity and lack of other relevant documents. In spite of time given by the school, the petitioner has not submitted to show that they have the real owner of the seized article. At this stage, it cannot be believed that the petitioner are bona fide owner or purchase of the scheme hides. The fake
This finding of fact is reversed by the revision.
Reverse. The revision
issue notice also.
Yes.
Issue notice.
Your Lordship has stay on the further proceeding.
The revisional court says that it is amenable to,
But without any slaughterhouse, in our state there is no slaughterhouse. How they procure the scheme, my lord? They are saying purchaser. From which place they are purchasing the schemes? Because there is no slaughterhouse. Maybe the state may support my submission. There is no single slaughterhouse in our state. How they purchase the
in this city also so many slaughterhouses here in Kolkata.
illegal slaughterhouse.
Illegal slaughterhouse. I am not seeing slaughterhouse.
I'll just issue notice and stay it and for only 1 week. Because see, this is the balance,
Right.
All illegal slaughterhouses are being operated everywhere.
Right.
And how so much of
Cattle, my lord.
original cattle, where from these people got it? This is smuggled out.
Yes, your lordship.
That's no impunity.
Grateful.
Stay of the impugn order. Stay of the operation of the impugn order till next date of hearing. Mr. Vishwal accept notice and seeks to file a response to the petition by next date of hearing. Lease the matter on 20th of
Notice to OP2 and 3.
notice to OP2 and 3. Lease the matter on 22nd of November. The interim order is operational till next day of hearing.
Good.
23.
Yeah, so question of proceeding. The petition number 1 and the informant are married. And on the basis of the
Petition number 1.
I guess,
Matrimonial.
they have married this issues.
Opposite party number 2.
But no informant.
What is his name? Nothing. Opposite party number 2 in handwriting you have written informant.
ନାଇଁ ମୁଁ ଲେଖିଥିଲି ଡିଟେଲ୍ସ ସେଠି ଷ୍ଟାମ୍ପ ରିପୋର୍ଟରେ କଣ କଲେ ନା 376 ଯେହେତୁ ଅଛି ସେ
address to the one, how notice will go.
ସେ ସବୁ ସେଇଠି ମୁଁ କିନ୍ତୁ ଡିଟେଲ୍ସ ଲେଖିଥିଲି ଆଡ୍ରେସ୍ ଲେଖିଦେଲେ ନାଇଁ ଫ୍ରେଣ୍ଡ
What do you say? Tell me, where are they?
ବାହାରେ ପିଲା ବି ଜଏଣ୍ଟ Both parties appear before.
They are there. That's what he said.
Informant does come, but the person number 1 is outside. And some other
at 2 o'clock.
No, Gujarat চাকরি করতেছে যদি lots of can fix a date.
Why we are so gracious for the accused?
No, gracious.
You should have become, you have traveled to informant to come here, she's a lady. And the accused who has really harassed this lady to save marriage, she has settled the dispute. And he will be given grace by the court and council and everybody. This is
in fact
he's not doing any service to the either the system or to anyone. Let him be here. See, the lady has come. Just see, you trouble this lady. Then, if you knew that the petitioner is not to come, why would you call the lady then? You could have asked for adjournment. This is see, the lady has come. According to appear on VC by 2 o'clock today.
VC. Yes.
Tell you. How many? 3 accused.
The entire family has been entered.
But that's right, 3 accused. And who else is present? Who else is present?
Yes, Sandeep.
4 accused persons. None of them are present. Everybody is working in Gujarat.
His father has come. Mother
365, 376.
Charge sheet was submitted on 294, 323, 341. But the cognizance has been taken by the magistrate by including 376 against the husband.
Cognizance is taken. Let's see. 376 cognizance is taken. You want crossing of a 376 FIR, calling the victim girl and accused persons, 4 of them will not come.
His father has come. In fact, he has come with them.
Tell them to appear in VC today or tomorrow. Tomorrow,
can I pray for?
Do you realize what must be going in the mind of the lady?
She is his wife.
Calling her wife will come, but nobody will not come. In-laws will not come. 4 of them.
Two men.
To show that you are torturing her.
To mention her, he has gone to India. He has gone for job.
It is not. But what about the other people? 4 of them.
His father has come. Father
has come.
Oh, father.
Anybody has come.
Father,
what's happened to see?
Yeah, he's passed by street.
Call the lady and ask in the lunch hour at 2 o'clock. And move application. Those who have come, it's all right. Those who have not come, move an application for exemption from appearance. Stating the reasons.
Yes.
I'll record that reason and exempt, and thereafter I'll do. Because unnecessary file again, this lady will be in trouble.
Yes, sir.
And lunch hour, Mr. Vishwal, ask her whether she's satisfied and he's happy or not in the house and all. Okay? 2 o'clock.
But one small prayer, item 49, only extension of time.
I have some personal difficulty. That is a
Extension of time for what? You have.
Your Lordship, directed to surrender before the London magistrate. That
For the reason stated in the application, the extension for time to surrender oblique appear before the court below is directed by the order dated
By order dated 6/9/24.
6/9 to be extended up till 30th. No, up to 30th. Yes.
24.
24.
Where to coming to this case, Your Lordship may kindly peruse page 17 of my brief, annexure 2.
Yes.
Why, my lord, I am saying so, Your Lordship, I will continue. Form 20F. A license has been issued in favor of one, Mr. Mishra, under the Drugs and Cosmetic Act, to purchase and sell the medicine and other things. Your Lordship, may consider license to sell stock or give it the sale for distribution by retail drugs.
I got it.
ISA Medical Store. Name is ISA Medical Store. Then Your Lordship, may can see that person has not been made an accused. How the investigating agency initiated malicious proceeding against the person, those who are not anyway connected with this case, my lord. Then Your Lordship,
what happens is license is somebody else is license are also let out, you know.
Right.
License in somebody's name, somebody else is running this.
He will be accepting permit. I am the son of one person, salesman. I have been to the medical store to hand over the food to my father, even the accepting for a moment.
What is recovered? You simply
that is cough syrup, medicine, and other things. Then it will come under the problem of 21, 24, 25 of Drugs and Cosmetic Act, my lord. If I have violated any terms and conditions under the License Act, my lord, then I will do.
No, what is now the investigation is going on?
My lord. My lord, I am no way connected. I am the son of my lord.
Don't tell all this to IO. I will give you liberty.
Your Lordship,
and I will consider it in accordance with law.
Page 12, my lord. Page 12.
I am not place करती.
I have received the information from the relaxation.
So they are relevant. At the time of receiving information from the reliable sources regarding illegal storage and selling of the contraband drugs like escort syrup, tablets by one MD Salim of Pitlagar in his ISA medical store situated at Saraiguda. MD Salim, even if accepting permit your lordship. Sir, allegation is against MD Salim. Then I have placed before your lordship page 17 annexure 2. Licensing stands in the name of one Sir Mr. Mishra.
I agree with you. All these things I agree. But investigation is still going on. Cannot dissect everything and
because, my lord, from the bare reading of the affair and other things, my lord, and the son of MD Salim.
Maybe you go and tell all these things. Who stops you? And I give a direction to the IO to consider in accordance with the law and deal with it.
Because
that's a better idea. If he doesn't do, then you have liberty to approach it.
Once again, I will not. Only but
you shall come. Right. Petitioner is an accused. Petitioner is arraigned as an accused in FIR number. What is this? PS case number 354 of 2023 for alleged offences. 24 for alleged offences under section so and so.
And 22-29 of NDPS.
Counsel for the Mr. Das, counsel for the petitioner submits that even if the allegation made in the FIR is accepted at its face value, no case against the present petition is made out because the he has relied upon the license issued in favor of one Sir Mr. Mishra to run what is that shop?
ISA
medical shop from which the alleged contrabands have been seized. he submits that he has.
That is license number, your lordship, can I?
Yes.
License number, dated.
No, number two. Number is there. He submits that he has nothing to do with the Aisha medical store. Medical store. Rather, his father is one of the employee in the Aisha medical store. For be that as it may, I am not inclined to interfere in this matter at this stage because the investigation is still going on. However, the liberty is granted to the petitioner to apprise the aforementioned facts to the investigating officer, who shall deal with the same in accordance with the law. In accordance with the law. With this liberty, the petition is disposed. Yes.
Can I say one thing, my lord?
Yes.
I'm so sorry.
Yes, it's all right.
Because the young chas, police will apprehend because my father is already apprehended. That is altogether different story. Till that date, no coercive action, sir.
You can't. Because it is a NDPS case.
No, NDPS no. It
is
FIR registration condition, say good difficulty.
Liberty is also granted to the petitioner to resort to remedy available.
खाली मत एति कि और थ्रू रेस्टिट्यूट एडी करता भी चलिबो से आ जाओ
Only 34 IPC and section 4 of the DP Act. In the meantime, compromise has already been done.
Who are they?
The
Suman
Mudali
and
Sundalata Pe.
Kapala Mudali.
Husband is there.
To the other accused.
Other accused?
Three accused persons are there.
Three accused persons. Second is the mother-in-law and third is the alleged to be the second wife. He has already married other. Yes.
Where are they?
Husband is present.
Do I need to repeat every time that there are three accused persons have to be there? How can I quash like this? I don't understand. How have you taken it granted?
See, two is appear, my lord. Two will be appear.
They are not showing any grace to the court.
No, my lord.
They are accused, they have to be here.
Yes. Petitioner 2 will be appear, my lord. Petitioner 3.
Whether he appears or not, I am not interested. If they are accused, they have to be here. They are asking for quashing, they have to be here.
Main accused.
How can I quash? Why? Maybe may not be. I am quashing insofar as the petition number 1 is concerned. I will quash. The rest of the thing I will dismiss right now.
No, next.
No, I will not waste time. In every matter, I can't keep on accountability.
For 90 days, husband or the wife is present.
So therefore, I will cause the FIR for the husband who is present.
13B also allowed. 13B application was also allowed. And he has already received the parental alimony.
I don't know. Where are the accused persons? I am asking. If the accused persons are there, I will quash it. Accused persons are not there, I will not quash it. Simple.
Others are another day is there.
Right. Release it after 2 weeks. Yes. Why are you advising the accused person not to come to the court? I am so liberal. I am saying that let them appear through VC. At least they should appear.
Other two will be appeared vessel.
I don't know whether they should appear VC or not. Don't know. How many times I'll keep on telling all this thing? I don't know. Yes, next.
Increment will come well.
Everybody will have to come.
26, the learning council will be mentioned after lunch.
After lunch?
26. The council has mentioned.
What is he asking for?
There the parties have come, therefore taken up after lunch, 2 p.m.
What is the FIR is under? Section 6.
At 2 p.m.
Let them come.
27. 27, my lordship. In this case, the file the CLMC petition for the expeditiously tried. Expeditiously tried, lordship. So in this case, the FIR has been lodged in the year 2020, lordship. 20. And thereafter, charge sheet has been filed 14/10/20. And thereafter, removal charge 22/3/2021. Thereafter, trial has been commenced. Evidence is going on. No, lordship. Repeatedly, someone has been issued the witnesses, but they're not. No,
some deposition. 24.
Yes, lordship. Depositions and the order sheet, lordship. Can you see the page 24? Out of 7 witnesses, 2 witnesses has been deposition, and the last deposition dated was 11 pages. Taପରେ to होने.
The matter is now transferred to some other court.
ताପରେ फिर सेटिंग pending अच्छी court. तो बस से ऊपर लेने या किसी development नहीं.
What are the offences?
Offences are
petitioner has
186.
Seeking quashing of the petitioner has filed the petition exploring the following relief. Relief ले लो, it will cure. To dispose of exploring the following relief. Relief Learn Council for the petitioner submits that the FIR is for the year 2020. Registered on 2020 and subsequent thereto, the charge sheet has been filed on 14/10/2020. However, the trial is not proceeding as per the expected pace. Therefore, he seeks the relief as mentioned above. Needless to say that the petitioner being the accused in the case is entitled to statutory and constitutional right of free, fair and speedy trial. Therefore, the prayer made by the petitioner bears merit. Accordingly, the trial court is directed to do well to see that the trial is concluded as expeditiously possible. Yes. Yes.
Belgium matter, my lord, and we double dated 14/11/2023, my lord. And you are on bail on 4/4/2023, my lord.
500. Yes.
29.
30th September. Sorry, on number. Yes.
Yes. LBW issued 3rd February 2004, but here
February
2024.
Yes.
But the bail he released on interim bail. Thought Sean was in, but could not surrender. He only to surrender and move for bail.
Petitioner was granted interim bail. However, he did not surrender as per the after the expiry of the bail period. Hence, NBW was issued has been issued on 3/2/2024. Learned counsel for the petitioner on instruction published that the petitioner would be surrendering before the court on or before 30th of November and resort to the remedy available to him under law. Subject to petitioner surrendering, it is set aside. Yes.
Co-accused already released. Co-accused already released.
No, you do it. Interim bail, you just I'll impose cost. Cost of 1,000. You don't respect the order where you want it to be indulgence. Yes.
My lord, I want to yes, tell me, this matter may kindly passed over. This matter may be kindly passed over.
NBW. Yes, tell me when you will do this. NBW issued on 15/5/2019.
15/5/2019.
And you was on bail?
15 March 2017.
17. Yes. March 2017. 1000 cost. Yes.
31. NBW was issued on 16/12/2020 and 10/4/2023. He was earlier on bail 26/6/2019.
2019.
19.
Okay. NBW is dated. NBW
16/12/2022.
16/2/2022 and 10/4/2023. 23. Okay. 1000.
32.
May I please the lordship, my lord. I was granted bail, my lord, on 29/3/2011, my lord. And Belgium NBW issued on 27/6/24.
Possible.
Yes. 500. Obliged.
33.
May I please, your lordship? I was on bail, your lordship, 24/9/2019, 9, your lordship, Belgium 26/8/2016, your lordship.
16.
Yes, my lord.
1000 each.
Only one person before, your lordship.
Nice. Only one of you have come, huh? NBW issued all of them. No.
26/8/2016, lordship, NBW against me, your lordship.
November कर दो 15th November on or before 1000
David oblige, your lordship. David oblige.
1500.
34.
May I please, your lordship? My lord, case under section 21B of NDPS Act, my lord, the petitioner is inside the jail from 15/9/2023.
CD got. Hello, CD is not CD call for CD. Yes.
My lord, already I have annexed the its trial. Trial has been commenced, my lord. All witness has been examined, my lord. The only individual independent witness, my lord, PW3. Kindly have a glance over, my lord, page 37, my lord.
You are in custody since
15/9/2023, my lord.
15/9/23. And do you have the depositions with you?
No, my lord.
Where are the depositions?
Yes, my lord.
Depositions of witnesses.
Yes, my lord. Only 3 witnesses, my lord. Page 37, my lord. It start from page 19, my lord. Only 3 witnesses are there. All witnesses has been examined, and the only individual witness is PW3, my lord. On page 33, kindly have a glance, my lord. Para 4.
Have you seen it? My lord, may kindly see page number 18, my lord. 18, my lord. Now, all charge sheet witnesses are already examined. Hence, the prosecution evidence is disclosed. Lordship. But since it is almost over, if your lordship can I take no. See, when bail application was rejected,
So withdrawn, my lord, not rejected, my lord. So withdrawn as my lord, it is not by order that, my lord. BLAPL 107 was withdrawn with liberty to file an appropriate stage, my lord.
No, trial court. Have you gone to the trial court?
Yes, my lord. After that, I moved to the trial court of a witness, but he rejected that no trace cause of action is there, my lord. But my lord, from 15/9/2000, I'm inside custody. All witnesses that makes an examine, and my lord, individual witnesses are only hostile, my lord. He stated that he reached the excise office, no outsider present, there except excise staff. On being asked by them, I put my signature on 5-7 documents. The documents were blank. When I signed on it, they forced me to put my signature despite of my refusal to do so. Nothing was seized in my presence. The contents of documents I signed on were not read over to me. No brass seal was given in my Jima. I had also not signed on my any Jima. I signed on documents out of fear as I am working in a liquor shop. I neither know or has ever seen the accused man.
Nice.
The only individual witness from 3 witness, my lord. Other 2 are the IO and 1 constable is there, man.
When your bail application rejected by trial court? 2024.
24.
Your bail application rejection, right on. Petitioner's application. Petitioner's bail.
29/7/2024, man.
When is that?
Bail application rejected 23/2024, my lord.
No, yes. Thereafter, the witnesses were examined, my lord. And you have to go to the bail plea of the petitioner has been rejected by the Lieutenant Special Judge Nimapada on 20th 20/3/2024. Subsequent thereto, how many witnesses? My lord, 3 witnesses. 3 witnesses. have been examined in the month of April, examined on 1 minute on 29/3/2024, comma 19th April 2024, and 1 minute, and 29th July 2024. Respectively. Since the witnesses have been examined subsequent to the rejection of the bail application, the petitioner is given liberty to renew the bail before the trial court. Trial court. Trial court. I'm not inclined to it. Yes. You remove your bail plea before trial court. Yes. Next.
May I please your lordship? On 5/2024, your lordship has make an order that renew the bail application before the learned trial court, and on 9/2024, after renewal of the bail application before the learned trial court, he has the learned trial court, after hearing the bail petition, pleased to reject the bail petition, and this is the second bail application before this honorable court, sir.
Yes.
In this case, sir, this is a case under section 302 IPC, and I am in custody since 17/11/2022. And out of 30 CS witnesses, 15 witnesses have already been examined, sir.
17/11/2022.
22. Okay. Yes. Have you seen the evidences?
The evidence is fine.
My lord, I don't. The detailed lordship may kindly have a glance. Now, have you satisfactorily read it, or you need time?
No, some time if you will.
Simply after 2 weeks. See, the prosecutor has been changed, so wait after 2 weeks. Yes, next.
36.
My lord, custody since 18/3/2024. 18/3/2024. Okay. Offences are FIR lodged on 30 to 34 IPC, with 4 of use on the act, and charges submitted figure to 120B and 34 IPC. Actual principal accused is the one suing the not the petitioners. Who stated in the order sheet. As page 92. When the charge was filed, charge sheet filed on 14/7/2024. 14/7/2024. Okay. Yes. And as per the order sheet, once illegal is the principal accused. Yes. And do you have the CD and all? Well, the detailed CD I do not have. The CD. Principal accused full device. Let him get this. My lord, get the CD. Yes. My lord, yes.
37.
My
May I please your manners? 37 mallards. And petition of filed bail application mallards. 6263 of 2024 mallards. And lordship granted bail mallard, and subject to verification of 6 VI, he shall be released on bail subject to verification of the criminal antecedent in similar nature mallards. And I have also mentioned in para 7 mallards the bail application reflected one criminal antecedent in similar nature, and also stated that the lordship granted bail but subject to verification of the one criminal antecedent, and that is their mallards.
Where is that order, bail order?
Mallards.
Where is the bail order?
Bail order mallards dated 25/9/2020.
Where is that? 25/9/2024 mallards. Now you have moved a modification.
Mallards.
Your bail plea is rejected now. So means rejection order. What is the recovery here?
Recovery mallards which is 170.06 gram, less than commercial quantity.
In the other case?
Other case is also mallard. I also para 7 mallards bail application mallards. That is 6 gram 360.
You are in that case.
No, my lord, yes. I have also mentioned mallards in para 7 mallards.
Lordship, I do not
create any hindrance for your my seniors liberty. Lord, kindly have a glance at para 3 of this IA that has been filed.
IA.
My lord, this IA for modification that has been filed. I'm completely unable to understand what is being stated here in the IA. The Lordship had fixed up this as per para 6 and VI, Roman VI. The Lordship had fixed certain conditions. But the last 4 lines I'm unable to understand.
Subject to verification of the criminal conditions in similar nature and report was called for and one criminal incident similar nature so and so and also I have also mentioned not properly written.
But I also para 7 mallards, reflected mallard, bail petition mallard, abandonment mallard, Dhanspur PS case number 47 of 2002.
Let's verify about this. Verify. Let him.
Only 2 page item and
information on the application. Yes. Yes, next.
38.
Item 38, where the personal also the marriage system law in custody is 16/5/2024. 16/5/2024.
Yes.
Offences are 492, 294, 323, 304B, 306, 34 and 4 DPA. And the merit system law.
Merit system.
And all together having separateness and staying all together separately.
What are the allegations?
Lawsuits, marriage in coaching process.
And the CS was called for, it's not available.
Marriage in coaching.
Awaiting CD, leaves the matter after 1 week. Yes.
It's a great man.
Yes, indeed. Yes.
39.
Yes, sir.
Lord, this is a review application seeking for review of the judgment passed by this honorable court in second appeal.
Yes.
Lord, it's a suit for recovery of possession and for permanent injunction. And the suit is dismissed.
You tell me what is the apparent error?
Apparent error is this, my lord. This is
paragraph.
Yes, my lord. My lord will kindly come to page 15.
15.
15.
15? 15.
15.
Okay. Yes.
The judgment starts, my lord. And
relevant paragraph.
Yes. That is at page 21.
21, yes. Yes.
Para 10.
Para 10, yes.
Plaintiff claims to have purchased the suit land from her mother-in-law, vendor, by registered sale deed dated 23/9/83, Hide Exhibit 7. The defendants have not challenged the same at earlier point of time, except attacking the same in this suit. The sole defendant as the plaintiff has filed title suit number 21 of 91.
You are defendant?
No, I am defendant. My father was the original defendant and subsequently his at his co-sharers, including Praful Kumar Devi, the vendor of plaintiff, claiming partition of their joint family property, which included the suit land. Now, this property is the subject matter of another suit, and the suit is pending in the sense of appeal before the appellate court, my lord. Because this is joint family property, joint family ancestral dwelling house.
Yes.
Mother-in-law has sold the property in favor of one of the daughter-in-law. That is why we claim that this being the joint family ancestral undivided house. This cannot be.
What was the suit?
This is a suit for recovery of possession. This is the present suit is for recovery of possession and for permanent injunction, basing upon the sale deed which has been executed by mother-in-law in favor of daughter-in-law, one of the daughter-in-law.
And who is the plaintiff in the suit? Who is the plaintiff in the suit?
Yes. But the earlier suit is pending in the sense of appeal before the London Appellate Court, London District Church.
I think this is a concurrent finding of facts, both the courts.
I could not understand.
Concurrent finding of facts.
Here. No, because suit has been dismissed. The suit which is filed by them, that has been dismissed. Subsequently, it was reversed in appeal. That is why, my lord.
Yes. Yes. Then what is the error you are saying?
My lord. Then my lord may kindly see. My lord, in one fold, I may humbly submit before you this honorable court, that since the property is right now subject matter of appeal before the London Appellate Court, And the nature of property is going to be decided whether it is ancestral property or not, my lord. Then one of the co-sharer, the owner, co-sharer, he sold the property in favor of one of the co-sharer, without the same being partition between the family members. This should not have.
That's the partition suit.
Yes.
Yes. Appeal is pending.
Exactly.
Yes.
That is pending there. And right now here, one of the co-sharer, he filed suit against me saying that I have purchased from the owner and that is why you do not have any right over the property, even though this is joint family ancestral property and this needs to be decided before the land appellate court.
Yes, you are appealing.
But they can complete analysis.
Yes.
The second point is the property.
You want to say that to the vendor of the plaintiff?
Yes.
He has not got a crystal clear transferable right unless the suit is decided. One pending in appeal.
That's what this is one point.
Yes.
Second point is this is a leasehold nodule land matter. Nodule land is a pure government land matter. It cannot be the subject matter of.
That's a finding of fact. I will not interfere. That's not apparent error.
So this is how maybe
that you argue that an appeal. Since this is, I am not exercising appellate jurisdiction. I am exercising order 47. Order 47, within the ambit of order 47, you can make out a case, then I can interfere. Otherwise, I will simply you relegate to the appellate court, you go and argue whatever you want to argue. On merit, don't touch.
No.
You show me apparent error within the purview of order 47. Yes.
The Yaddas report, which is submitted before the London Trial Court, that is at Exhibit 9, it says, my lord, this is a nodule praja land. The petition is mentioned as nodule satwa nodule praja land.
Yes.
Then, my lord, the ROR is also submitted before the London Trial Court at Exhibit 6. It also reflects that this is a nodule praja land. Satwa So, nodule praja land cannot be subject matter of alienation. If this is so, the cell deed itself is a void deed. So this is a point of no matter.
Is it your alternate plea or it is you say that it is ancestral property partition suit is going on, appeal is pending.
So this can be,
you can't have both the stand which is completely
this can be subject matter of partition, but cannot be subject matter of cell matter. This can be subject matter of partition because it can be divided between family.
Even if it is nodule land.
Nodule land, it can be divided between family members. At any time, government can resume it, but it can be divided between family members. But it cannot be subject matter of cell matter.
Third point. Another point I understood. Third point.
And I have also challenged the same in my written statement before the London Trial Court. But here, while this judgment was passed, inadvertently, I can say to that extent, inadvertently, it is mentioned that there is no challenge at all regarding this question of law in your written statement. But I have mentioned in my written statement, but to that extent,
where does it say that there is no? Where does it say?
Rules 21.
20
bottom
defendant is not even able to
establish any sort of rival claim of ownership property when the claim of their predecessors in
establish. It can be ground, but you could not establish. That's it.
That for 7
property wherein then in that
the matter. Next para.
In that view of the matter,
yes. When the plaintiff had the alienable right over the property and she having executed the registered sale deed held at Exhibit 7, neither the defendants of their predecessors in interest of challenge the same on any specific ground were filing suit except questioning the authority of as above, which has been negated, and it is only here.
Yes, show me your written statement. Show me. What is that?
Written statement is at page 36.
36? Yes. Where have you taken that?
Para 4, my lord.
Para 4, yes.
That the contents in para 4 in the plaintiff's false and denied, and strictly to be proved by your honorable court, it is submitted here that the suit land are ancestral properties of the defendant and the plaintiff, and let Praful Kumari Devi has got no capacity to sell the land to the plaintiff. It is also submitted by the defendant that the defendant plaintiff managed to clear the alleged documents, which is not binding to the defendant, even if it is admitted in evidence.
Specific against it.
Yes, what do you say?
There are 3 points argued by my lawyer. First is, an appeal is pending between interested parties.
Yes.
Matlab, the suit was dismissed. Appeal was filed in way back in 91. That appeal was dismissed for default. 8 CMA applications were filed.
Yes.
With huge limitations. That limitation was questioned in a CRP. Judgment is reserved. The appeal is not in existence because the appeal.
But what he says is your alienable right has not been crystallized because of dependency of the appeal.
No.
That's what he says.
When this suit was being heard in second appeal, the appeal was not in existence.
When this
yes, appeal was not in existence.
Restoration application was pending.
I have not disturbed you, sir.
No, sir.
I have not disturbed you. It was never restored. 8 CMA applications were filed to restore the same. All the CMA applications were dismissed. Ultimately, a restoration limitation was condoned, which was challenged in CRP, and CRP they have contested, judgment is reserved. Unless limitation is condoned, the appeal is not in existence. Secondly, when this appeal was being heard, the second appeal was being heard, in the written statement, they have only simply stated what was read.
Yes, paragraph.
Paragraph. Yes. Suppose a sale deed is, I am putting the sale deed in for declaration title. A counterclaim should have been filed.
Yes.
Once a counterclaim has not been filed, even if it is raised in the written statement, that the court has found that it is not a nozzle land. It is, she had, Professor Kumari Devi had the right to alienate the property, and rightly it was passed. Suit was dismissed. Appeal was.
What are the evidence you laid on paragraph? What are the evidence you laid?
I examine, I also cross-examine from his mouth. It is coming out that this is a nozzle land, and I submitted the document. Here also, my lord, I have annexed the documents, ROR, cell deed, everything. My lord, my kindly see.
His appeal.
Page 33.
Appeal memo, it was his appeal, and the appeal memo, my lord, he has not. Suppose I'm before your lordship, I may take 1,000 grams, but when during the argument, suppose I do not urge a point, and subsequently I come to the knowledge that this point was raised in written statement that not argued. Once I don't argue before your lordship, I lose the right of arguing before your lordship.
Yes.
Now in the review, can your lordship interfere? Because there is no error apparent. He has not raised that point. Secondly, my lord, the appeal which he now says, the appeal was not in existence on the day the second appeal was. If your lordship wants, I can produce that document.
This appeal was restored. Subsequently, it was challenged, subject matter challenged before this on the floor.
It was not restored.
Restored.
CMA applications were filed. If your lordship will call for that record, of course it is document is reserved in court number 14. I can produce that. I have given a date chart in which 8 CMA applications were filed, and 8 CMA applications were dismissed for non-prosecution for non.
It was restored. It was subject matter challenged.
Show me a written statement where have you said that a partition suit is pending. Show me in written statement. Come to a written statement. Where have you said that?
He has simply stated that portion.
Where have you said that?
Well, it is
this suit was supposed to be decided on the basis of the pleading of this suit.
Yes.
You can't bring something else in a review petition to say that the judgment is wrong.
No, this.
How can you fall within the exception 1 or 2 to that 47?
That is true, my lord. But during evidence, I produced this document before the trial.
There is a ground for you to agitate in the appeal stage, not in the review stage.
Section.
No, it's not good. In trial, I submitted all these documents, my lord.
You show me in your written statement where you say that a suit for partition is pending, which is eventually went up to appeal.
No, that is true, my lord. But
then you are gone.
But during the trial, all those material facts were brought to the knowledge of this honorable court. I produced this.
Material fact orally bringing to the notice of the court in a suit proceeding is neither here nor there, unless it is pleaded.
Let me verify the document. My lord, I have submitted report. Verify.
No, I've seen the written statement. That
Not in written statement. My lord, I do understand. I cannot.
I will elucidate from the pleading that the apparent error was cropped in the final judgment. And the court has not considered the fact that the appeal is pending. Any legal right has not occurred.
That is true, my lord. But during the appellate stage, my lord, during the appellate stage, my lord, I have produced many documents for this, the learned appellate.
Have you moved application under 43? Order 43. Challenging additional document on record, nothing?
No, that I will verify.
No, show me any application under order 43.
Well, I will verify.
What have you done to?
My lord, one chance may be given to me. I will arrange him.
Agent.
They already, letting me satisfied.
Might have dealt with it.
I will produce.
Pleading, see, the problem with you is in a suit proceeding, you have not pleaded.
So that will
appeal, you want to rely on something, you will not move the application under order.
This is right, my lord. That is not my case. This is right, my lord. I do understand, my difficulty.
You are not saying that it is apparent error.
My lord, what you would have done, if what you would have done, you would have filed an application for bringing those additional.
That's what I'm asking. You have not done that. That is the whole difficulty.
If I have not done this, my lord, then I do not have a case. But if I have the case, my lord, that's what I will look into.
First step not allowed the appeals because I proposed the appeals. So this was
register cell is produced by him, by additional evidence. No,
whatever you have done.
That I will verify.
What you have done.
Well, I can say whether I cannot vote. This would be difficulty.
Let him come after two weeks or 3 weeks. Let him satisfy. Better you file appeal and do whatever you want.
Interestingly, my lord, this point which is raising this review, he filed a 47, which was standard, not challenged. Yes, your lordship note in 47 application, when we move before the executing court for 47 application, it is just like reappreciation of all the documents.
Yes.
In 47, he has raised this point. The 47 application was dismissed, which has not been challenged in Supreme Court.
No, not like this, madam. The 47 application.
Anyway, I asked a pertinent question. You satisfy me whether you moved an application under order 43 to bring this fact on record.
Yes.
True evidence. Because in the pleading, in written statement, you have not said anything.
No, madam, that is correct. That is correct.
Then
in appellate stage, it has been decided. I would say.
Moreover, madam,
appellate stage pleading is neither here nor there.
No. Certainly.
He should. You may hold it for thing. But if it is divided to the pleading in the court below, in the suit proceeding, the pleading in the appellate is neither here nor there.
Even if I file a document, the appellate court will not discard the document at the threshold. He will keep the documents to be considered during the final stage. If you have produced, that would have been ground in the second appeal. Madam, can you see the grounds in
now? Let him satisfy. I am not.
There is no ground. Second appeal. The document is executed.
Ground is material, my lord, because if I have produced all the
ground in a second appeal without there being a pleading in the suit.
No, not like this.
And that will be a ground for review.
No, by this process I cannot develop.
Then you have satisfied me there.
No.
Yes. 3 weeks after. Yes.
41. Malad, fix a date as a date fix.
Yes.
Malad, item 40, Malad, that item number 40.
My lord, somebody mentioned for adjournment. Yes.
My lord, I am on behalf of Mr. Bhavan Sarai.
Where? 41? Yes.
This item may kindly be passed over.
Sorry?
Passed over.
Copy of the application. Let counsel for the petitioner shall supply the copy of the petition to Mr. Janna, AG. Okay. Leave the matter after 3 weeks. Yes.
42.
32. On appeals for the petitioner in the interest of justice, adjourned to after 3 weeks. All review petitions are marked to this court or what?
Single benches with the previous order of last period.
Yes.
43. Item 43 on behalf of Mr. Agarwal, can I pray taken up some other day?
Sorry?
Maybe taken up some other day on behalf of Mr. Agarwal. Item 43.
Okay. On request, adjourned. Yes.
Short argument. May I pray the case of the year 2012. May I pray for it?
2012. Achha, 2012 matter. We were enjoying the stay.
I was
What is this case?
I have no, my lord, he has requested.
Mr. Agarwal is very successfully managing it for more than a decade.
My lord.
1 decade, 2 years.
Not a short adjournment. He's very badly placed.
Let us see. That may be, but let us see. What is the entry model? Entry model. What is the challenge?
So my learned friend can assist. He doesn't have also fight.
No, kind of dispose of the case.
Dispose of name.
What is the stage of the type?
I have to take instruction there. Because finally, I mean, as per my
entry model was selection.
As per my instruction, that was dismissed for non-prosecution. Thereafter, that was restored.
As an entry measure, no course of action shall be taken against the petitioner. The petitioner is directed to cooperate with in the investigation, inquiry, and if any, this is the order. Investigation was going on. There is no course of action. You could have filed the charge sheet, you could have proceeded with that. It is virtually anticipatory bail in true sense. True sense, it is anticipatory bail. What have you done?
Your lordship say once it was dismissed for non-prosecution. For that reason, my lord, I was taken as
it was somewhere, it must have been restored. Because very short adjournment, 1 or 2 days adjournment.
I has not come.
On behalf of Mr. Agarwal, counsel for the petitioner, a short adjournment is requested. And this matter is pending since 2012. An interim order is operating from 5/3/2013. In the interest of justice, last opportunity is granted to the petitioner to argue the matter, release the matter next week. It's made clear that no further adjournment shall be granted in this matter in any circumstance.
Entry model.
Entry model 2013, no course of action. Who is going to arrest you now?
How is
who is going to arrest you after 12 years?
You're asking a fix it for tomorrow even.
No, next week an entry model to continue. Yes.
44.
Problem.
Yes. For extension of time.
44?
For extension of time for surrender.
Extension of time for surrender.
But order has not been annexed.
See, 2019.
Order has not been annexed.
2019, see, the first order was passed on 8/4/2019, directing him to appear, MW. He didn't appear. He moved an application on 8/2019, 2 weeks time further granted. Now he's asking for this.
Twice, my lord, that cannot. My humble assumption, twice it is even expanded.
That's right, but what have you done?
Given sufficient opportunity, my lord. Your lordship can recall that order, my lord. Or your lordship may dismiss this.
No, but you tell me, why have you not executed the NBW?
NBW should be issued against him, my lord. Should be executed, my lord.
Why have you not done it?
Normally, once, my lord.
82. He is asking for extension because you have not, you have failed to execute the NBW. If you would have executed, you would not have asked for it. In fact, in true sense, you have forfeited your right to oppose. You don't execute the NBW. And the people are coming to the court, say, yes, I am ready to surrender. But I do have to oppose, you tell me.
But not for the opportunity also granted to him.
That's the whole thing.
Because there is a court order, perhaps that there is the reason he has not been arrested. So if there has been dismissed, and I will instruct the IO to proceed with the case. Or a lot system.
Supported subject to verification of fact, verification and earlier release on the bail and for this item. The matter was taken. This is the IA? Or what is this?
IA number भी देना है.
IA is listed?
It's a उकील भी रहेगा कि ना जड़ के उकील अपने आगे के फैल.
Yes, 2834 IA. This is an application filed by the petitioner seeking extension. None of the for the petitioner. Extension for time to surrender before the court. The matter was earlier taken up. The main matter was earlier taken up on 8/4/2019 and following order was passed. Okay. Following order was passed. Next paragraph. The petitioner was directed to petitioner was directed to surrender within 3 weeks. Within 3 weeks. Within 3 weeks by the aforementioned order. However, the petitioner did not surrender as per the direction of the court. Rather, choose to move an application for modification. By filing IA number 1513 of 2019. The said IA was disposed of by this court by the order dated 2/8/2019 by extending further 2 weeks time for surrender. It appears from the record that the petitioner has not complied with that order as well. Instead of complying the order dated 8/4/2019 and 2/8/2019, the petitioner has moved the present application seeking extension up for further time. For the reasons stated in the application, I am not inclined to extend further time to surrender. Surrender. Therefore, the application is dismissed. The IIC, which police station is this?
IIC, my lord.
Which police station is this? Lift of anything.
Nothing has been mentioned in the question.
IIC Dongri Poli, PS. Is directed to execute the NBW already issued in favor of the petitioner.
A copy of this order.
Yes. 45. What are the offenses? 304B, 306, 498A. That's going on. Yes.
45. Item 45, 46 mallards. There are certain defects like authentication fee, which are material mallards. Will remove the defects mallards, I pray.
See, the petitions are filed in 2023.
I understand.
It is, you filed it on 18/4/2023.
Mallards. I understand mallards.
1 year? No.
6 months.
About 2 years. 1 year, 6 months. You are not cured the defect. I think you are not interested.
Mallards, I beg apology. Mallards, there has been some difficulty.
What is this matter is about?
This matter is with regards to the Bhushan Steel power plant explosion mallards, whereby there has been criminal cases which has been initiated against the present petitioner and another person. So, mallards, yes, mallards.
What is the stage?
Stage mallards, we have to take instruction because the assisting counsel and my learned senior, the assisting counsel has suffered an accident and Mr. Hon'Ble is badly placed to do mallards, and hence I prayed for getting the
Then you pay some cost. Okay.
Mallards next week.
No, you pay some cost. The present petition has been filed by the petitioner on date. अभी जो date बोला क्या date था?
18/4, I guess.
On 18/4/2023, the registry has pointed out certain defects. Matter was taken up on 27/6/2023, at 13/9/2024, and opportunity was granted to the petitioner to cure the defects, but defect has not been cured as yet. The land counsel for the petitioner further seeks further time to cure the defects. 1 week time, the last opportunity is granted to the petitioner to cure the defects, subject to the petitioner paying cost of rupees 1,000 to be deposited with the High Court welfare. Both the matters. Pay 1,000 in both the case, cure the defect within one week. Okay, leave the matter. 1,000, 100, both the matter. No, you pay. You are Bhushan State. You are Bhushan State. Go and pay. Go and pay. You should feel it to each of it, otherwise you will never cure the defect. Cure the defect immediately within 1 week. Least after 1 week. Okay. Yes. 47.
Can you pass over?
Okay, pass over there.
48.
Yes, 48.
The petitioners are brother and sister.
Notice was issued to the OP2.
Yes. Notice submission. Yes.
My lord. I'm challenging the.
I'll just pass over. Let us see if somebody may come.
I got a short date. Delivery card.
Notice was issued to the opposite party number 2. The notice has already been served. However, none appears for the opposite party number 2. In the interest of justice, release the matter after 1 week. Yes. Yes.
49 somebody mentioned. 50.
59.
59 mentioned.
Arjun. Somebody mentioned. Yes. 50. 50. Yes.
In this case, my London Police insist for a supply for the deposition of the witnesses. I pray it is taken up next week so that I can take from.
Probably the LCR is available before this honorable show. Let it be taken by pendrive and they let them supply the copies to me.
Take it
and it may be added in the hearing list in the hearing list.
You edit in the hearing list.
Yes,
and let him take the.
After supply of the copy, let it be added in the hearing list.
Yes, prepare the. Yes.
It is of the 24.
Yes. I'll just.
Is not there.
Okay.
Is after the video call and is the petition number 4 is the father of the petition number 1. He is also present physically.
And father is, and who else is not appearing? There are four
active.
Yes.
Petition number 1 is the husband, 4 is the father-in-law.
2 and 3.
2 and 3, I have filed a petition to dispense with their personal appearance.
Where is the joint affidavit?
Informant.
Yes, Mr. Vishal. What? Yes. What he says? See, you need the mic.
Yes, I have moved defense against them. And she does not want to proceed with.
They happily married?
Happy.
Yes, right now. At the instance of opposite party number 2, FIR number so came to be registered against the petitioners. The allegation against the petition is the petitioner number who is appearing?
1 in the
physically. Petition number 4. What is the name? Borun Kumar Madgal, petition number 4, and opposite party number 2 are present in person, and also represented by their respective counsel.
One is appearing from video.
Respective counsel. They filed the self-attested copies of their identity, Aadhaar card, which are taken on record to establish their identity. Petitioner number 1, who is the husband of opposite party number 2, is virtually present, and represented by the counsel. Insofar as petitioner number 2 and 3 are concerned, they are the sister-in-law and mother-in-law of the opposite party number 2.
Sister
Present in the court. However, an application has been moved on their behalf seeking personal exemption from personal appearance. The application is taken on record. For the reasons stated in the application, their personal appearance is exempted.
2 and 3 and 2 is the younger brother of petition number 1, and 3 is the uncle-in-law.
Okay.
Brother-in-law, younger brother and uncle.
And 3 is the uncle. To the uncle of the petitioner number 1. Petition number 1. Petition number 1. Who has filed the affidavit? Harimali.
The Borun one. Petition number 4.
Acha. The parties have filed a joint affidavit dated 29/8/2024 inter alia stating as under para 1, 2, 1, 2, 3, 1, 2, 3. 1, 2, 3. The opposite party number 2, who is present in the court, on the query from the court, the opposite party number 2, who is present in the court, states that she has already married with the petitioner number 1, happily married with the petitioner number 1. There is any issue? Is there any issue? Happily married with the opposite happily married with the petitioner number 1 and residing in the in-laws house. She has no grievance against her husband or against the in-laws. Due to matrimonial discord and the previous incident, which pre-marriage incident, the FIR was registered. Since he is already married with the petitioner number 1, he doesn't want to proceed with this case and join with the petitioners praying for question of the proceedings. Regarding head to the Mr. Vishwal, let me talk for the petitioner. State submits that the parties have settled their dispute. The opposite party number 2 has already married with petitioner number 1 and happily residing in the in-laws house. Since he is not interested to prosecute the petitioner, there is no legal infirmity in causing the FIR. Regarding head to the aforementioned, it is clear that subjecting the petitioners to trial in the present case would be a futile exercise. Therefore, the case of the petitioners are covered by the judgment of the Honorable Supreme Court in Gyan saying so and so. Accordingly, FIR number so and so and constitution proceeding arising therefore request here. Yes.
26 met. On the petitioner present, my lord. Opposite party number 2 also present. We have got married.
You are married?
Yes.
Maybe. Yes. Where is the opposite party number 2? Surekha Naik. Surekha Naik. Yes, Mr. Vishwal, just check it out. Ask her.
this matter next week, and detail.
Because you have only filed the copy of FIR, nothing else.
Nothing else.
So you files, yes. Mr. Bharat, Land Counsel for the petitioner seeks an adjournment to file additional document and seek instruction of the present instruction regarding the present status of the case. Release the matter after 2 weeks.
Yes, 2 weeks, ma'am. Obliged.
Continue score.
51.
Yes.
Petitioner is was rather working as a factory manager of Hindustan Coca-Cola Beverage Private Limited. Ballad.
Yes.
And he is neither the owner nor the occupier. And the offense alleged are under Section 12 of the Boilers Act 1923. And cognizance taken in a very cryptic manner, Ballad, non-application at all by the learned magistrate, which I can demonstrate, Ballad. Because no offense is read out. And secondly, Ballad, there is a requirement for obtaining of the sanction from the Ballad statutory authority. That is Ballad
Boiler set.
That is Ballad the chief inspector.
Boiler set. Do you have extra copy of it?
I would go.
Yes. Now the problem is that side.
There are no issues, Ballad. In fact, this case has a very checkered career. Initially, this case was admitted on a particular, one second, please. On a particular date. The case was not listed, but it was shown to have been disposed of on that date as dismissed for non-prosecution. And there were interim order in this case, Ballad. Subsequently, moved in application for restoration. The restoration was allowed on that ground itself, Ballad. Case was not in the board, but it was somehow rather the order sheet reflects the case has been dismissed for non-prosecution. And while the matter was restored, this honorable court cannot, the application that I have filed again before the Lordship, Ballad, restored to its original file. It has to be restored along with the interim order, along with the interim order, obviously. But now the honorable, this honorable court directed that we have to move an application for extension of the interim order for the simple reason the status of the case was not known. And now that we have obtained the status, it is as it is, Ballad.
Where is that order?
Ballad, the restoration order, Ballad.
No. Where the status of the case is to be required to be.
That is order number, Ballad, 2. Yes, date.
Okay.
I'm sorry,
This is Mahapatra stage.
Yes.
Order. Yes.
First of February 2024, Ballad.
But the para 7 you just see accordingly the CRLMA. Now,
yes.
As a consequence, there the CRMC so is restored to 5 years.
So restoration means restoration from the stage and back.
The entire thing revives. Yes.
But thereafter we have to move an application for extension. You are given liberty to file a separate application for extension of the interim order. So that
order has to be wrong, right? Whatever it has to be restored. Everything is restored.
Yes.
Separate application is not required. Have you moved the separate application?
Yes. They have moved. Direction which you moved.
Where is that IA? IA number?
IA number 420. 420.
The number is very bad, so that's why I can't tell out. But no more, this stigma is no more.
So I escaped.
For the reasons stated in the application, the interim, the same is allowed. The interim order dated, where is that interim order?
29th November 2011.
29th November 2011 is restored. Restore. Okay. Insofar as the main matter is concerned, that counsel for the state seeks an adjournment as she has been engaged recently by way of last opportunity and the matter for final disposal.
Madam, again, 26th or 27th?
27. Madam, no further adjournment will be given. I am only accommodating once. Okay. Because this interim order is operating since 2011. 29/11/2011. That is why it was dismissed in default, it was restored. Once it is restored to file means the interim order also restores, come to the operation. Somehow that was not continued since last two occasions.
In fact, it was never dismissed. Somewhere other formula type, maybe whatever, but yes,
Restored to file.
Yes.
Means it is restored.
Exactly right.
Yes.
No, I didn't copy of the order.
You worry that violence act.
Is that?
Violence act is that? No, drug and cosmetic. No. Violence act. No, what she has given this, file the take on.
Ma'am, am I actor there? Like,
file the take on.
no, तुम से actor भी बेचने के कारण क्या ना actor भी बताओ.
File the take on.
It
But I want that it should be filed so that it will be. Yes. Act is there.
May I bring your lordship notes? I know the lordship noted, but I think 78 notes. I have 70 of lordship copies notes. There's a noting that matter is taken out to claim notes. Only bring it to lordship notice notice.
I will we'll reach that. Yes. Next. Your Lords, the question we are praying for quashing of the proceedings. Yes. The question which arises is that petitioner is a shipping company. Prosecution has been launched under the Payment of Wages Act. The point that we are raising is the act itself is not applicable to merchant shipping companies. There's a separate act which governs them, which is known as the Merchant Shipping Act of 1958. Okay. So this is the question of law which we have raised. Now, we are being opposed by this union government. So I don't know whether the Union of India is there or not. Who is appealing?
So, central.
Who is appealing? State is also made parties, but it's the union who has to respond. Who is prosecuting you? State. No, union, but state also we have given them copies. State of Orissa represented through Labor Enforcement Officer Central. No, who is prosecuting you? Union legal government. Central government is prosecuting. Last occasion, last 2-3 dates also, my Prime Minister Padhi was appearing. The deputy, the ASGI. The order sheet also reflects that. Yes. Non-appeals for opposite party, non-appeals for Union of India, despite service. In the present matter, the interim order is operating since. Interim order is there since the beginning. 17/11/2015. 17/11/2015. Although Mr. CORAM Mishra, senior counsel appearing for the petition, is ready to argue the matter, but in the absence of the counsel for the opposite party, the matter cannot be taken up today. By way of last and final opportunity, for release the matter for final disposal and submit the interim order to continue. Yes. In fact, here also the Merchant Shipping Act would be required. So if it's not there, I'll give a photocopy so that tag it. Tag is there. Merchant shipping. So payment only 2 acts, few provisions only also. That's about. I'm grateful to you. Yes.
53.
May I please your lordship? I'm busy, my lord.
Are you getting you? 53.
53.
Okay. Yes, tell me.
53, my lord. This is a case where your lordship has occasioned the last time to hear the matter, my lord. In part, this is a case, my lord, where the petitioner is an advocate.
There's a noting that item number 53, the matter taken up 3 notes. Maybe for that reason, the other counts are not there, but my understanding is saying that in the second revision notes, the second revision, that's a revision filed by the state of Odisha. And the state revisions is filed by revision because the London trial court's note, by considering the application for Butcher's notes, what he did was he said that only for IPC officers they remanded send the matters to this agent and saying that she Act is not applicable notes. Challenging that particular part of that orders, the state has this revision notes. In this case, no limitation matters overload. My lunch senior says during launch of our notes, he has not been provided for copy of the review application. I am due to want to supply. I would supply the copy notes.
Okay. In so far as criminal revision petition, 597 of 2016 concerned, Mr. Das, counsel for the vigilance, has undertaken to supply the counsel for the opposite party.
I have also not received.
Yes.
That was not the moot point. No, I argued for 3 days. Thereafter, specifically posted today. Matter is analogous. Whether he will be discharged by the CJN, he has not been discharged. The special judge discharged so far as 31 and 13.
But you get a copy and get ready. Who will supply the.
The case which has been filed by Mr. Das, my lord, we have only received the copy from the notice, my lord, that is on the ground of a limitation, my lord. That petition was the only service. So on the merit of the
entire paper. Yes. Continue. At least the matter.
May I pray for a specific date next month?
Give me the period.
Next month.
12th. Yes.
I will also get a copy.
Sir?
I will also get a copy.
Yeah, of course.
54.
Your Lordship, may keep a date post 12th, Your Lordship, because my senior will not be available.
Not wait. 13th is post 12. When you ask 13th.
Your Lordship.
The ticket journal. No, please, Your Lordship. Here is the case, my lord. The present petitioners filed this case for crossing of my lord 1cc case lodged by the OP number 1. And the last occasion the lordship had, there was a marriage in the year of 2005 and both the parties entered into an agreement 2008. Thereafter, my lord, the present 1cc case has been filed after my lord 2013. Thereafter, my lord, the present petition came before lordships. My lord, crossing up the proceeding on the ground, my lord, once a registered document has been issued by a registering authority, my lord, whether the criminal court has power to decide to declare the document null and void and prosecute as per the IPC. And your lordship waiting for the response of the complainant, OP number 1.
Lordship, I am appealing for the OP. She is physically present today. Today only she has engaged us. Lordship, there are 2 things in this case. First, the present petitioner developed extramarital relationship with another lady on the pretext of customary divorce. During pendency of divorce, she has married to the second lady.
Okay.
She has admitted all these things in his divorce proceeding, Lordship. Kindly give a date. I will file a counter.
See, this matter is pending since 2016.
Since 2016 it is pending, but today only I have yet to file the Bhina matter.
But fact of the matter is
separately only 2 days after, Lord.
I will give you time, don't worry. But fact of the matter is she must be staying separately.
Yes, living separately. In fact,
what are you going to get out of it?
Nothing. This is a classical case how a person victimized a lady. During soft.
Have you asked your client that what exactly she wants now?
Lordship said present today.
You ask because she
another
She is not getting, she is getting any maintenance?
No, looks not a single.
Has been received. Your lordship, kindly come to page 21.
One thing, you have married somewhere else.
That's it.
But you have married this lady also for some time.
10 ଲକ୍ଷ ଟଙ୍କା ଯୋଉ ନେଇଛନ୍ତି page 21 ରେ mention ହେଇଛି ବୋଲି ସେ ମନା କଲେ।
That was deposited in the court. Not a single file has been given to the that lordship. But there is another thing, lordship. The 18 lakhs lordship.
Listen to. At the end of the day, you are not going to get anything except money.
Lordship.
10 lakhs or 20 lakhs, whatever. The money you want to get it. You take the money, settle in your life. You can't live with this man.
Lordship. That is my case. We have preferred and matter before this on report because the petitioner is working as a professor in Hilani. He is getting more than 5 lakhs per month. And the awarded money is only 18 lakhs.
You have not taken any money.
No, lordship.
10 ଲକ୍ଷ ଟଙ୍କା ସହିତ entire alimony has been deposited and your lordship kindly
Matter is yet to be filed, lordship. We will prefer and matter.
Shall I send you to mediation and work it out?
mediation failed. She did not buy a tender. Your lordship kindly
Exactly, there is no possibility of
the mediation.
mediation, the honorable chief justice sent it to the mediation. She did not tender. My client knowledge came to the restaurant to Odisha. Right. Your lordship kindly go through that.
Ask her whether she is ready. She didn't cooperate with non-affiliate for the parties. Opposite party.
It's a fixed date. She will appear.
Ask her whether she is interested for mediation. Once it was sent to mediation, she did not cooperate. What to do?
Lordship says agree. Next day.
आप मेडिसिन कोऑपरेट करिए अब केस खत्म करके कितने दिन लड़िए
सर केस तो लड़ियार सेमिति ये नाही किंतु प्रोसीजर टा मते ठीक लागुनी काहे कि ना
Given the duty of verifying certain documents of the bank, my learned senior had placed certain judgment before laws, which is there in the compilation. There's one judgment of Honorable Justice Savitri Ratho, which Lords had instructed directly covered. If they had any objection, otherwise Lords were inclined to
now change of guard. Madam, they relied upon couple of judgment, and one of the judgment of this court, they are directly covered by that. Therefore, the matter was heard, and the State Council had sought time for seeking instruction. Insofar as that part is concerned, whether the case of the petitioner is covered by that judgment or not. Justice Ratho's judgment is there, that they are directly covered by that. What do you say? Do you have the file and have you seen that judgment and all? When?
Copy of the judgment.
I will account it to you only once because first time this matter is coming up after this. When can you tell me? Otherwise, they are directly covered. I am satisfied that they are directly covered.
Some time to examine that judgment whether that is possible.
See, I'll tell you if I am correctly remembering. The issue is a lawyer had verified certain documents, and those documents were accepted as a collateral for the purpose of granting loan. Loan was granted, and eventually it was found that the documents were wrong. So a case was registered, making the lawyer as a party. Now there are two issues. One issue is if a lawyer gives an opinion. My view was when a lawyer gives an opinion, it is a judgment of error, and that basis you can't prosecute. But once a document is given to you, original document given to you, you are interested to verify it, and you verify and say that the wrong document, you say that it's correct. On that basis, then lose the loan. Then in that case, he is liable for prosecution. That's what my view is. But there is a judgment of this court where it says that even verification of document done by a lawyer
Even if it is wrong and it is accepted by the bank as a collateral security, he cannot be prosecuted. That is the judgment. He is directly caught by that judgment.
Supreme Court has
Word upon opinion and verification. There are two different. Opinion may be error of judgment. Error of judgment. But verification of document also covered. So that is why they are directly covered by those judgments.
Let us go through that chapter.
When you tell me. Not a big matter.
And the Honorable Court was pleased to rely upon the apex court judgment.
Judgment also. Covered judgment. Complete covered judgment. Shall I put it on Friday? Friday, small issue, legal issue and the law is involved. Friday. And please give the judgment to her.
On the last date of supply.
No, last date, everything is gone now. And give you one more set.
I think my lawyer must have got the judgments in the
We have those three judgments. Two Supreme Court judgment, one. Do you have that with you? Just check it out. Otherwise, ask them.
No, sir.
Just see. And Friday evening, she will ask for time. Give the judgment right now. Give the judgment. Only give that judgment and facts and tell me whether covered or not. If it is covered, don't argue.
Yes.
I told you that you are here only to assist the court, not to oppose.
I think the court would note.
Prosecutor's job is to only assist the court. Don't stand and oppose for everything. If they are covered, simply say yes, it's covered. Yes. Yes.
Virtually in the note by that, in paragraph 9, we are giving the reference of all the judgments.
Sir, better you give it because better you take it, huh?
Put it the paragraph of that judgment. Citation.
Get the judgment citation. Yes.
Yes.
Yes, sir.
Here your lordship wanted to know on the last occasions as to the judgment of the family court. This is the copy with the husband and wife.
Written is Mr. Pandar and Counsel petitioner submits that meantime the marriage between the complainant and the husband and husband and opposite party number 2 complainant to who is the co-accused along with the petitioner filed a petition on
married husband of one.
Unless one has dissolved the marriage, ground of cruelty raised by the husband was according to DP filed by the opposite party number 2 is the built in the light of the examine certificate yes. Yes.
This is the judgment of the family court.
You are the mother-in-law?
No, we are the married sisters-in-law.
Married sister-in-law?
2 is the husband of one of them.
One of them.
Oh. The police
Yes, who is appearing for stay in this matter?
Chappal.
Matrimonial dispute. Matrimonial dispute.
Matrimonial dispute, notice was issued and the opposite party number 2 is not appearing. Opposite party 1 rather is not appearing. And meanwhile, on the ground of cruelty, divorce petition is allowed.
Yes.
And why this sister-in-law and wife, husband of sister-in-law will be prosecuted? And she filed a appeal against the degree of divorce granted on the ground of cruelty, meted out to the husband by the wife. The appeal is also dismissed.
Because of non-appearance.
If appeal dismissed, cruelty ground is established. The sister-in-law and sister-in-law's husband will be prosecuted on 498. I don't know. Why should they suffer? And she is not appearing after notice was issued to her. What do you say? I'll allow you.
Yes.
If you want to file some written note, you file it. You give it, I'll do it.
Still they want to. If you want to file. It is a complaint, see, I want CC case. Basically, I'll cause it. Do the first. If you want to file, you have a liberty to file it. Within 2-3 days, you file it if you want. Yes.
Okay, sir, your lordship is keeping this for final.
Legal judgment, what is this? That nothing. 2016, this matter is pending unnecessary.
Interim order.
And she might have been settled somewhere.
They are already.
She also might have been settled. She is not interested in you.
No, she has opened her own center in Metangal town. She is success.
57.
Yes, sir.
That matter where the dispute between two cousins. And the amount involved, my friend is badly placed. He has instructed him to seek for passo.
What passo? Why don't you settle the dispute?
It was referred to mediation, and mediation failed because of his attitude. That is also reflected in the. I would have been also he is badly placed in senior.
Okay. Joint request. Yes.
Interim mode of
entry mode to continue.
58.
The advocate appearing in this matter before it was transferred to us has passed away 10 days ago.
The lawyer,
So
we representing the family of the
I kindly fix a date.
appealing for the petitioner and adjourn the matter.
Our wakalatnama has been filed.
Entry mode to continue. Yes.
Great.
59.
Yes, sir.
Mr. Senior has been engaged. Allegation against the CMO of Paradip Port Trust.
Well, before your lordship, was the chief medical officer of the Paradip Port Trust Hospital.
Yes.
While he was holding his position, there were a series of let me just give the background. There was one of the doctors in the hospital, there was a case of sexual harassment against him. Now, once this allegation was made, the petitioner, who happened to be the chief medical officer, he called all the staff nurses to his room and said that why was I not informed about this earlier, about the sexual harassment thing earlier, before it was made public or he reported it. And while doing so, he is said to have made certain statements which have resulted in the present case being registered under section 323, 294, 506, 354, 354, capital A1 to 509.
What is the statement?
The statement is this, the statement which has not been corroborated by, in any of the 161 statement, kindly come to page 41.
Yes.
Page 41, towards the middle of the page. In caps, it's written, if you allow to, 41.
Yes.
This is the final form where the investigating officer has summarized the entire case, and inculcating this statement has found place here. Has your lordship got page 41?
Yes, I'm there.
And about 10 lines from the bottom of that page, there is a sentence which is in within inverted commas in caps. Should I read it out, Manoj?
Yes.
More to my staff, let's Manunko Soha 6.
Yes, Mr. Kanu says. Yes. Yes.
Here, a criminal case has been initiated against the petitioner, who is a lady, my lords. The allegation are that she has submitted a false matriculation certificate and a false +2 certificate to get the membership, to get the dealership of petroleum, my lords.
Even without this certificate, she would have got it. Be it as it may, my lords, there is an arbitration clause in the agreement itself, and my lords, thereafter, arbitration has proceeded. My lords, we have filed a claim statement against the company. Company has also filed its counter. Rejoinder has also been filed by us, and the proceeding is going on. It is at the final stages of hearing, my lords. The hearing will go on.
Yes.
So, my lords, under the circumstances, it's purely a civil dispute which I am fighting with the litigation. And in the meantime, they have also stopped the petrol pump, blacklisted me, and stopped the petrol pump. So, it basically, my lords, it is purely a civil dispute. Wherein, my lords, the company is fighting me in the arbitration level itself. And my lords, if at all there is fraud, then the arbitrator is going to decide it. If there is fraud, my lords, the dealership will go. She has invested around 3 crores in this petrol pump.
By utilizing false documents, he got the dealership.
That is the allegation.
There is an arbitration clause.
There is an arbitration clause, and arbitration also, my lords, has substantially progressed. But it is before Justice V.K. Mishra. My lords, we have filed a claim statement. A written statement has been filed by the company, and my lords, rejoinder has also been filed by us. So, my lords, and in the meantime, she has been blacklisted. Petroleum, my lords, petrol station has also been terminated.
The arbitration proceeding, eventually the arbitration proceeding will decide the dealership part. What will happen?
Dealership, and whether the documents are forged or not.
If it is found to be forged, then what is the penalty?
The penalty.
Arbitrator can't. Arbitrator only can say that the fraud vitiates everything. So therefore the license goes.
Yes.
That extent only can do. But what will happen to the forgery which has been taken place or not taken place? And what will be the penalty? Only criminal court can do that.
Criminal court can do that, my lord. Your lordship is absolutely.
Eventually, what you say is hold your hand insofar as the criminal case is concerned till the arbitration.
My lord, because no, I'm not saying that, my lord. What I'm saying is if the matter has proceeded towards a civil dispute, my lords, then, my lords, the criminal dispute. There are cases where criminal liability as well as civil liability will ensue, my lords. I'm not disputing that.
Whether if you forge the document to get the license,
my lords,
the forgery part is the criminal liability that has to be decided by the criminal court only.
Criminal court, true, my lords. What your lordship is saying is absolutely correct. But once, my lords, the company itself is arbitrating against us, my lords, then the litigation has to come to its logical end.
That litigation, the arbitrator will decide whether the license should continue or it will not continue. Rather, the criminal court's finding may have some bearing on the arbitration. If you are convicted, suppose you are convicted, then on that basis the arbitrator can say that to the Chandiva and Naidu. Utilize Chandiva and Naidu and say that to vitiate everything.
Arbitration.
If you are acquitted, the scenario will be different.
Continues, completes 10,000.
My lords, what my.
So I can't hear what he's saying. Kanor ko Subuniji. Speak in mic, please. He's speaking in your ear, I can't hear.
Who is speaking? You.
Oh, okay. I thought he's also arguing. Okay, I'm sorry.
Yes.
He wants to hear what he what I'm suggesting before your lordship is let this matter be kept pending for some more time. Let us see if I can.
I have strong objection to it. I'll tell the reason, your lordships. Lordships, first of all, your lordships, elaborate documentation of the merits of the case and detailed examination of the witnesses will be done at the stage of the trial. Sir is one of the rare counsel who has vast knowledge both in civil and criminal cases. Lordship, civil case and criminal case can parallelly go together. There is no dispute. Lordship, as civil case and criminal case can parallelly go together. The only exception being section 43 of the Indian Evidence Act, will and probate. Your lordships, in this case, your lordship may kindly come to the certificate first in CRLMC.
Yes.
The certificate which has been filed by the present petitioner is in page 2, your lordships.
Page 2.
Yes.
Yes.
The certificate, your lordships, says that the matter out of which this criminal miscase application arises.
But today,
before this honorable
Mr.
court in
Kanungo
whatever.
is seeking for adjournment.
But your also the interim order may be vacated, your lordships.
A week after, well, CBI
Interim
is,
order may be vacated. Otherwise, I will argue this matter, your lordships.
next week, let it come up. Next week, let it
One
be.
last chance.
I'm sure he was very serious. Generally, he doesn't ask for adjournment. Sometimes, you know.
Well, as when I'm caught in the corner, well.
Lordship may give a fixed date.
Yes.
61.
Obliged.
Lordship may give a date.
Yes, yes, date will be given. Give a date, particular date. Yes. Obliged. Yes.
May it please, your lordship.
Item 61.
61.
Yes.
I don't have the power, my lord. At that point of time, I was that side, so. May I please submit.
Let him file the power. Huh? Let him file the power. He filed the power. And now you have already filed or going to file?
I'm going to file.
Okay, file.
Had it come 1 week after?
Yes, after 1 week.
In order to continue.
In order to continue.
Man.
52.
What possible 330? Tell me what is this case? You can also argue what is the problem. What is this matter? Initial examination report up to 1.5 years.
The NDPS Act, section 20B, of NDPS Act.
Yes.
Karim Gonja of 85 case.
No, what she says, if I'm not wrong, come to the prayer. He says that after 1.5 years of filing the charge sheet, you have filed the chemical analysis report. Therefore, it is entitled for doing. You are in custody.
They have already released them.
May bring forth to enlarge the petition on default due. He say, what she says is the charge sheet is filed without chemical examination report, so therefore it is an incomplete charge sheet. Hence, he is entitled to default bail under 167(2)
Yes.
of CRPC. That's what he says. She says, isn't it? But she is asking for adjournment. You get ready. Okay. Adjourn to question.
May I please your lords. On last occasion, my lords directed me to how many rupees I have to pay to my maintenance, your lordship.
Yes.
Here, your lordship, in the net case, I have paid as per the direction of the court ruler per month 1,800 rupees.
Yes.
And I have already given from the date of initiation to date of judgment, your lordship. And they claim, my lord, they claim that from the date of application, when they filed the case, net case was filed, and it was disposed of on 27/4/21. And they filed the miscase on 25 CRPC on 4/5/22.
Yes.
Till the disposal of the case, my lord, net case, I paid the maintenance of rupees 1,800 per month. And as per their claim, your lordship, as per annexer, it's 56, my lord, and their annexer 4, your lordship, sorry, 58.
Yes.
And they specifically mentioned, I beg apology for that. Annexer 5, your lordship, sorry. I marked.
Yes.
They specifically mentioned in page number 65, from date of 6/5/2022 to 6/8/2023 at the rate of 15,000 per month, that is 2,20,000
2,25,000 is pending against me. But my lord, as per the lower court, you have to pay the 2,25,000 within a paid claim. But from the date of order to till the date of order of the lower court below, I have to pay 2,25,000. But as per the order of the civil judge, your lordship, from the case of initiation of the case until the judgment, I paid your lordship per month 1,800. Yes. My lord may decide how much I give.
What has been cost for 15,000 per month? The intel, he paid the intel. 1,800 is the intel, subsequently stopped.
So what is the due amount? You tell, finish it up.
No, I don't dispute. Last occasion I have accepted whatever amount will be decided by my lord, I will accept.
But what, you tell me what is the due amount? You tell me.
Adjourned 4,26,000, 4,12,000.
4,12,000.
Yes, ma'am.
According to you?
For the 15,000.
According to you?
According to my lord, as per the application and the petition was filed on 22nd.
4 lakhs?
12,500. We asked for the order, the affidavit we have filed before the learned court below my lord. On 62,000.
Okay, according to you, how much?
According
According to what is the
15,000 right, but I have not given to the 15,000.
Tell me, calculate and tell me how, according to you, what is the due amount? So in between I fix something. And finish it up. See, he's giving a figure. I'm not going by that figure. He says that 4,12,000.
Yes.
And you tell me what, according to you, what? In between something I'll decide and finish it.
40% I will ready to pay. I asked it. 40%.
That is your matter.
No. As per their application, I will tell you.
You give 50% of the amount which he says. Finish it up. If 50% is more, according to you, you tell me what is your figure.
ସେମାନେ କହିଥିଲା 40% ଦେବା ପାଇଁ ଟୋଟାଲ ଆମାଉଣ୍ଟ ତା ବି 2,22,000 ଟଙ୍କା କହିଦେଇଥିଲି ଗୋଟେ ଦିନ ସମୟ ଦିଅନ୍ତା
2,22,000.
He filed an application before my lord for posting. I am only claiming my area. That is my.
Put an end to everything. Take 220 and finish up.
For one time settlement. My lord, as on date, the lordship said that 4,12,500 as on date by area. There is something.
This is maintenance only. What happened to the matrimonial dispute?
The dispute was on the moment he filed and divorce case to be separate. His allegation was adultery, and that has been not proved in the trial court. Award has been passed 15,000 per month because he is a employee.
It's all right. What is now the status, marital status?
But I am unmarried.
He is already married.
He is married. I am living with my brother. That is my problem.
What is the alimony awarded to you in the divorce?
15,000 per month.
That is alimony. Permanent alimony, nothing.
Nothing.
Nothing has been happened.
The judgment of the
I just don't refer to papers.
Nothing was good.
Permanent alimony is not about it. However, maintenance is granted. This is at the rate of 15,000 rupees.
Yes, ma'am.
Per month. And you keep on paying what is used. Why don't you give one time something? Forget about the maintenance. Pay something one time and put an end to it. That's what I was suggesting earlier also. This 2 lakhs something you pay that year. That will go
up. Final କରିବା ପାଇଁ ମୁଁ ଚାହୁଁଛି
Last occasion, lordship wanted to know that the amount must be fixed and not be.
You forget about the maintenance part. You think of giving a permanent maintenance, a lump sum amount, so that we'll put it into this. I'll set aside the order. One time maintenance you give and finish it up. Everything area of 4 lakhs according to him is accrued. How much you will pay? You tell me. Definitely, he will not be agreeing to 2,20,000.
ବୁଝିକିରି କାଲି ରଖିଦିଅନ୍ତୁ I will ask tomorrow.
Whatever amount you want to pay, that we can affidavit.
ହଁ ଦେବି ନେବି ଦେବି ଚିଠା ନାହିଁ ମୁଁ ପେମେଣ୍ଟ କେତେ ଦେଇଥିଲି ମୁଁ କହୁଛି ନା କେତେ ଦେଇଥିଲି
Shall I send to mediation and work it out?
ଭଲଥାନ୍ତା ହଜୁର ଭଲଥାନ୍ତା ଆଉ ତ ଲାଷ୍ଟ
Objection କିଛି ନାହିଁ, but the whatever amount he said.
Mediation ରେ ବସି ଖତମ କରିଦେଲେ
ମେଡିସିନ କରିଦେଲେ ବହୁତ ମାନେ
matrix deriving out of
But interim protection shall be vacated.
no, I'll continue.
But which that has been upheld by this and that.
I'll tell you, if interim order is vacated, then that will affect the mediation. I'll just give
I will order the
out of a direction for maintenance, grant of maintenance to the opposite party number 2, by the petitioner. Opposite party 2 or 1?
Both are belongs to CORAM.
By the petitioner. By the petitioner. There is claim and counter claim regarding the areas of maintenance to be paid to the opposite party. On the proposition from the court for this one-time settlement between the parties have agreed to mediate the matter before the mediation, High Court mediation center. High Court mediation center or district court?
district court
But the parties will not come. They belong to
ବହୁତ ମାନେ ଅସୁବିଧା ସେଇଟା ଲଙ୍କା ପୁଟ ମାଇଲଡ rural area
district mediation. You can appear through VC also. The Koraput district mediation center. Mediation center. Awaiting the mediation report. Leave the matter on 22nd. 22nd.
interim order
22nd of this month. Yes.
interim order
Interim order. You one time and finish it.
ଅବସର ମୁଁ ତାକୁ କହିଥିଲି ସବୁ ବାପାଙ୍କ ଦେହ ବି ଖରାପ ରହିଲେ ମା ବି ପଡିଛି ଦୁର୍ବଳ ଭାଙ୍ଗିକରି ମୁଁ ବି ମାନେ ଯାହା ଆଣୁଛି 80-90 ହଜାର ପାଉଛି
Salary certificate I have annexed and that.
You are working as
mechanic in
Mechanical assistant at Sunavada.
assistant mechanic head nine আছে
yes
Item 64, my lord, I am for opting to kindly talk up next week, my lord.
The proceeding
on
130 NID proceeding there, my lord. Company is not a party, my lord. It is 100 time. On it, case is applicable to all here.
Next week, company
on request court. Yes. From opposite party now. Yes.
65.
Please, lords. Your my lord, on behalf of Mr. Chhape, kindly taken up next week.
Interim order is there.
Interim order continue. Yes.
I am appearing for the opposite party on behalf of Mr. Chhape, kindly taken up.
He has taken several times.
Next week, my lord.
Last season, another councillor has appeared, my lord. Interim order is referred in favor on behalf of opposite party number 2. Adjournment is sought. The justice please the matter on silent session. Interim order shall continue. Take up.
So blessed.
66.
Password. Sir, order photo.
What this midnight password? What is this matter?
challenging order for cognizance, my lord. Offense is 307, my lord. Clearly, that is murdered from the FIR, so charge sheet along with the evidence of witnesses.
You are for opposite party number 2?
I am.
Okay. Yes.
The annex all the documents are annexed here, my lord. Charge sheet and FIR and almost all the statements.
Yes.
His name is first. Milan Mukhi name is first, my lord. That will be
Just trial, my lord.
You will read it.
Not read.
Yes, correct. Counsel for the petitioner seeks an adjournment.
68.
All the matters which Vishwa, all the matters which are being adjourned, get ready. Only I will give only one adjournment. Beyond that, no. Yes.
68, my lord.
Yes.
My lord, this matter was sent to the mediation center
Yes.
because it is passing of proceeding under section 498A. And mediation is going on and it will take some time. So adjournment may be allowed.
Matter has already been referred to, refer for mediation. Mediation process is still going on. Awaiting mediation report, adjourned. December 1st will be. Yes.
Obliged.
70.
The petitioner here challenge the order of discharge by the annex 9, as page, running page. And the petition has been forced to come before this all the thrice matter. The short and structure of the case matter. The opposite number 1 was filed, initially filed by the annex number 1 complaint case against the petitioner.
Yes.
And that was under section 153(3), that was sent for the police for investigation. And my lord, by the annex number 2 as per 20 on final form has been that there is no case.
That's right.
Accordingly, there was a petition filed. In that protected petition, cognizance has been taken, and when this petition has been challenged the order of cognizance by the criminal mischief before this order of cognizance. And unfortunately, that petition has been dismissed. Again, my lord, when the petitioner filed at the time of charge, the petitioner filed.
That was dismissed on merits or?
No, my lord, that was on absence, my lord. That was on.
But we've just been engaged in the matter. We filed our Vakalatnama.
Yes, my lord. As my lord, my lord was running page 38. That was
13.
38, my lord. That CRLMC has been dismissed for non-appearance, my lord.
Okay.
Then, my lord, the case was posted for charge. On the particular day, the petitioner filed a petition for discharge. And my lord, by my lord, annex number 9 as page 55. My lord, as have a glance at
what is the ground of discharge?
My lord, according to the same of the relief, one civil suit is pending. Ether, my lord, allegation they are the brothers and sisters. भौणी मैंने केस फाइल कर भाई मैंने भाई हमको न जणे कि तांगे नारे म्यूटेशन कर दी थी सोलो क्रॉस ऑफ द मैटर अकॉर्डिंगली भाई अनेक्शन 5 my lord the informant file a civil suit matter same जगह में कि civil suit को फाइल कर छी and that is pending when the competent court is pending in a civil matter.
But how will you get over this come to page 55 last paragraph?
Yes, my lord.
Page 55, last paragraph. Read it. $55.
Yes, madam.
Last paragraph.
Yes, madam. The instance case or complaint case.
Instant case is a complaint case. There is no such provision under section 239 CRPC to discharge an accused person, especially when the case is instituted otherwise in the police report.
My lord, when this
So the said petition is not maintainable.
when they according to the same cause of action, man,
That's right, but the application was not maintainable. The trial court is rightly rejected. You are challenging that. How will you get over this?
Let it become another case over the.
Okay. Are you expecting an amendment in the CRPC by the parliament in between?
One my sole submission where civil.
This is a legal issue. This is the legal issue. You have to answer. Your petition was not maintainable, therefore rejected. You have to satisfy me how 239 is maintainable in the complaint case.
That is right. That is right.
That's why it is rejected. Rightly so. You have to get over this.
I have challenged the order for conviction in a criminal.
That is dismissed in default. Thereafter, you move the application under 239. Now this 239 application is dismissed, saying that it is not maintainable. What is wrong in it? You are telling that.
Well, that is right. When my sole contention is that when the civil matter, a man has not penalized for two punishment. Civil suit is pending. So that I can decide over car say. Accordingly, say same offense 406 420. How that's a matter charge has been filed.
That's the problem with you now. How to get out of it? This.
The case is pertaining to 711.
You are the brother of petition number 1, opposite party number 2.
Yes, madam.
One. Brother and sister, both of you.
Petition number again.
Ponchi, Nirasi Khotua. Your sister?
Yes, ma'am.
Is she your sister?
No, madam. I am going to be a brother.
I know that you are going to be like that. You are for petitioner. Who is your sister? Informant is your sister?
Yes, madam. Ponchi.
Ponchi is your sister.
Ponchi.
Brother and sister. Right.
Ponchi, Nirasi, wife of Arjuna. There are six brother and sister. One of the sister.
Brother and sister, 420, 460. What is
not only that, my 205 it's a
technically a very difficult case. But otherwise, I'll send it to mediation, sort it out. Sort it out. Brother and sister, see, the allegations are very similar. Only for property and all.
The allegation only this.
The civil suit is pending. Sort it out.
This has been a long-standing civil dispute. May not be. Might be a futile effort is what I'm saying.
Annexure 5 is there. Suit is filed by.
This is a long-standing civil dispute between the parties. It would not be settled by mediation.
Mediation job so that
brother and sister suit is pending. Why don't you settle? I don't understand.
What
will you get if you send your brother?
Let's me fix a date. Let me speak with
the fix a date before the mediation center.
Fix it.
Try and come. If brother and sister, if we can work it out. If it doesn't happen, then I have to dismiss it. Because on the ground of maintenance, maintainability.
We can participate in the mediation, but if you have
that negative
not as well as I was doing.
It. Saying that brother and sister dispute, the civil suit is pending, then you will not settle. I can do that also. I will because he has invoked 482. I can invoke 482. Forget about this maintainability. Allow the petition.
What's my fix?
You are the sister, you are trying to proceed with your brother, the suit is pending. You don't want to mediate also. You don't want to go for mediation. Even I allow this petition. Think about it.
We will abide by my laws.
Be positive and try and settle. The existence of opposite party number 2, the criminal prosecution has been initiated against the petitioner. The petitioner and the opposite party number 1 are brother and sister, and there are civil dispute pending amongst them. Therefore, I am of the considered view that the parties can explore the possibility of settlement before the mediation center or High Court mediation center. Accordingly, they are relegated to the High Court mediation center. The coordinator is directed to fix a date and inform the same to the parties. Awaiting mediation report, release the matter on 22nd.
Esta sahati ko achhi par हमको साखी आरंभ हो सकता है I appoint and why.
Since the matter is now referred to mediation center, it would be expedient that the parties should jointly make a prayer before the trial court for an adjournment. Yes. An application, it's sent to mediation. High Court has sent to mediation. He
has paused all the documents and taken the property of the sister in his name. He was the custodian of the property.
The problem is, it is going to your property, not his property.
No, father
is the property of your parents.
Parents are passed away.
Fighting for the property owned by, have you earned anything in your life?
Only allegation.
Have you earned anything in your life? Your father's property, he is also, he is also eligible, his sister is also eligible. He was the elder brother, he was the custodian of the property. He has committed and false documents. He is property. Both of you are trying to return some money.
Sole allegation ala bhumi manaka na
Settle the dispute. Better. I will try best. Better to settle.
Try best.
You revive your relationship as brother and sisters. Yes.
71.
71 minutes. This is a matter wherein there are two separate CLMCs, 5 minutes. There, and this is a case wherein proceedings were initiated by opposite party number 2.
There are two petitions here.
Two petitions.
Yes.
One is 1376 of 24 and another is 779 of 24.
Yes.
Now these proceedings were initiated at the request of the opposite party number 2 millions. Who is the wife of the petitioner in one of the petitions. Now she had if I may kindly see at page 20 minutes of the petition 1376 of 2024.
Yes.
Now the allegations against the present petitioners, who are the husband and the husband's parents, were that they have tortured her, demanding dowry, and after that, on 11th December,
What is the matrimonial status now?
matrimonial status is Miller, they are separated, no proceedings for divorce has been filed, but she has filed a separate case seeking
Staying separately, not separately.
not judicially separately, not judicially separately. Yes, they're just staying separately. She has filed matrimony case seeking.
Now, what is the other case? What is the other one?
Similar, in one of the petitions, it is the father-in-law, mother-in-law, and the separate petition, it is only the husband-in-law.
Yes.
Now, this entire case that I'm stating,
Lordship, there is another CLMC which they have filed. That is CLMC number 3190, where the Lordship have directed to go to the mediation center. And Lordship may have a glance at the order.
What is happening to mediation?
That will be directed by the Lordship.
It is going on. No, going on. The information is not correct. It has been directed in this said order. I have a copy of that. I'll show that after the wife appears in the said CLMC in which I had filed for caution of the duty proceedings, after she appears, a date will be fixed before the mediation center. She has not. That case has not come up. That case has not come up, and after she appears, it will be sent for mediation. That is, I filed for caution. Now what is through him and participate in the they have appeared in that case, because that case has was not posted before my lords. After the number, let's tag.
It is 3109.
Connected matter being CLMC?
CLMC 3109 of 2024.
24. In the connected matter, CLMC so and so, the parties have already been relegated to mediation. Mediation process. The mediation is still going on. Hence, the council for the parties jointly request for adjournment of the last matter and the matter on certain session along with the EA1. So the CLMC so and so, awaiting mediation.
Lordship, my humble prayer is that Lordship allow me to file a show cause.
Yes, you are within.
You first mediate. Mediation may be successful.
Lordship, may I have a glance at order date?
File it, no problem.
And share us a copy.
Share the copy.
Yes.
I'll file there in the counter.
Copy.
Supply the copy. Meanwhile, the council for the opposite party seeks to file response to the petition. Let him do so.
Let's may fix a date as early as possible.
When that date is fixed, there
was no date fixed for mediation. The opposite party was supposed to appear in court. After which the date was supposed to be fixed. I have to make a mention before this court so that other CRMC could come to this court. Let's make
CRMC is on
tag along. Let's may fix it day after mediation. Both parties are in mediation. Yes. They can come. High Court
conjointly pray that they would be appearing
on Friday.
On Friday, 8th of November.
For the on it. On it.
Before the High Court immediately.
4 p.m. 4 p.m.
4 p.m. Both of you appear in the High Court mediation.
High Court yes.
Published. It is referred High Court mediation in members. And that was High Court mediation. Okay. Now there's an interim order in all the three matters, please.
Interim order continue.
72.
Malad, this is the matter. Yes, the same matter, working of 6 of PID Act. Yes, last. Yes, sir.
The contention solely that since it's the same similar case, Rasmita Pastor case has been quashed by the Supreme Court. The proceeding may be quashed.
What happened? Supreme Court, what happened?
That is the Supreme Court stayed.
No, that's pending. Not taken up.
And in this case, it is not similar because Supreme Court issued direction to the petitioner to cancel the bail and to surrender and to move to the principal office. He has not done that without complying the order of Supreme Court. Has approached the Supreme Court for questioning the process. The order of Supreme Court has not been complied.
Where is that?
Manoj Supreme Court that both the cases were complied. That Supreme Court says no, it is not proper. That SLP number 4129.
Where is that order?
Order dated Miller. That order is there.
Where is that?
2nd April of 2020. 2nd April of 2020. Order is there. I can.
No, have you filed that? 2nd April?
2020.
Yes.
I have given it. This is tagged by the Supreme Court, straight to the Supreme Court. So, Honorable Appeals Court says that the tagging of both the cases is not proper. Each case has to be tried separately. And cancel the bail of the petitioner.
Which part?
Last paragraph.
Yes.
That we have not complied that order and approach the Supreme Court order for it to do for passing of the proceeding.
Yes, sir.
And that Rasmita Patra case is not only good because of the Supreme Court ruled that it is political.
That is justice argument. But that is pending, both the judgments are.
So now, right after.
But the only thing is, why are you not complied with this order of Supreme Court? Which one?
Supreme Court order. I am ignorant of that, and I am not coming here for bail. It's a question of.
So that's right, but there is an order. How do you comply and you can't support to that order? Some other proceeding.
And I'm not supporting that one.
That's what is contained.
His contention is fine. I don't disagree with his contention. I don't know why, in which stage it is there, whether he has complied.
Seek instruction on this.
Madam, I'm on a different way. What he is supposed to say is that this case comes out of a case where it was a tagged proposal. This was a tagged, both the cases. In the first case, it has been passed. 6 OPID Act has been passed. And till the order of this Supreme Court, it was a case without having 6 OPID. When this becomes an independent case, 6 OPID Act is revived. Now my submission is that basing on that order, Where it is not I am not connected with Rasmika Patra. My case, in my case, it has been quashed, referring that Rasmika Patra. Rasmika Patra refer correctly, my case has been passed. What I said, it was tagged. I have not tagged it. This honorable court has tagged it. Being agreed with this order, UW went to, state went to Supreme Court. Supreme Court said that's a different case. Fine. If it is a different case, and when the party is same, the cases arises out of the same facts, same plot of lands, everything is same. Why that order will not be applicable to my case? My submission is that.
Everything is all right, but Chandrasekhar Pati himself went to he was a party to this SLP,
my lord,
where there is a direction that you surrender and get separate bail.
My lord.
And why have you not complied with this?
In that direction, it has been directed to the UW to file every and each case of every and each complainant. There are something about 50 complainants are there. They have been died. They are yet to file another complaint. They have only filed only that two, three cases have been filed, but not more than that. Then in which case we are going to ask for the bail? Until and unless they file all the cases where the bail was cancelled. This is not a case I have registered.
No, the come to page para 15 of this order of Judge Supreme Court. Further, the High Court has directed the respondent hearing to be released on bail while noting that they have been arrested, misinterpretation of the order dated so-and-so and misconceived legal advice. However, we note that the order dated 19/12/2018 was clear in its terms and language while directing that FIR should be registered in the matters where it had not been registered yet. Investigation will be taken up by the IOC so-and-so, so-and-so. It is in furtherance of the said order, UW Bhubaneswar PF has rightly registered the FIR and arrested the respondent. The finding of the High Court in routine order based on the reading of the earlier order so is clearly based on misreading and misinterpretation of the same. Direction contained in the order dated so nowhere directs that the only one FIR is sufficient and every fresh complaint should be investigated under section 173(8), applying the magistrate so. And thereafter, the 16 para 16 cases stands dismissed. According being granted to the respondent stand cancelled. It is directed that respondents shall be required to seek bail afresh in each separate FIR. This is the investigation agency is directed.
They are very slowly filing. Suppose they will file 40 cases. I have to ask for bail in all 40 cases.
That's what we did.
What I say, I have not come here for bail, or I am not.
In this case, have you got the bail?
Pardon?
In this case, have you got the bail?
No. In this case, the bail.
At least you do this.
Comply with Supreme Court order. Before getting into complying this one, my submission is that once 6 OPID Act is passed, because this is a part of the main case. So, I understand that. I mean, that is the point. Once it is passed, but if there is an order to this effect, at least you comply with this order for this FIR. For this FIR, you comply with the order of Supreme Court. I don't follow. So what this FIR is? This FIR you are seeking question, my lord. In this FIR, at least you comply with the order of this court, Supreme Court. Okay, with the bail. Okay. I'm not. I don't want to get the bail until. Very honestly say, until and unless 6 OPID Act is passed, I'm not going to ask for the bail. Wrong. There is an order now. I don't disagree. That's why I'm not raising the question of bail. I'm not raising the question of bail. Are you not trying to sabotage the order of Supreme Court? No. This way, no. You are. You are. You have indicated. That will not get the bail, therefore I you telling it. In this case, I have a telling Supreme Court. That's something that is wrong or rightly, the order has been passed. Would you agree? But my question is, I want the relief.
Your admission that you may not get the bail So therefore, you resorted to this proceeding. If nothing but sabotaging this order,
That is obtained from, madam, that is behind the scene. That is behind the record, on the record. On the record is, I want 6 OPAD access first.
I'll examine it, complying Supreme Court. My lord. Complying Supreme Court order, I may examine that. You will get the bail. No.
But no, that I know that is the reason. No, of the court I am saying. That is the reason. Very honestly I am saying. 6 OPAD Act, intercept, accused soul. So, that scenario I am not going to repeat it here. Because I was accusing. I am not going to that in. Whatever it is,
I am only afraid whether I am trying to dilute the order of Supreme Court order by interfering.
No, not at all.
Supreme Court has taken cognizance of any aspect of it.
Supreme Court has taken, no, Supreme Court has not taken cognizance of any offense. Supreme Court says the second FIR, which was tagged, is illegal.
Yes,
we in nowhere. This
is separate FIR for every offense.
1 minute. So this honorable court has never also passed the offences in the previous order. What they say, tag the second FIR in the first one.
Yes.
Which was taken place in the year 2014.
Yes.
Tag it with that, and the charge sheet filed in this case will be treated as supplementary charge sheet. There is no question of passing. And automatically, when the charge 6 OPAD Act has been passed from FIR of 2014,
yes,
and this matter is tagged, means 6 OPAD Act is gone. And again, when this becomes enemy, it's a separate case. 6 OPAD Act is valid. That is very.
How many accused persons are there? Two of you are there.
Three.
Two. Chandrasekhar Pati and Niranjan.
Yeah, in this step too. Somewhat interesting in the informant which he says, what are the informant which FIR, he is saying, then you talk to Jaga Kelly, he paid me I paid him the money, he gave me the land, he registered the land, I got the RO. I am paying all this tax or everything is going, but he has not given the position. Interestingly, the land, exact this land, that has been attached in the case in 2014. What is
I am confronted with a situation where I have to, if I agree with you, I have to rely upon a judgment of this court, which is subject matter of SLP, one thing. And second is, the same judgment is being staged by another bench, is a per inquiry.
Let me tell you, per inquiry.
And over and over that, you have obtained this order and you are trying to support. In what way I will, venture into this case, I am not able to.
I am coming to the per inquiry. Let us come to that point.
First thing, which judgment you are relying upon? Justice Panigai's judgment you are relying upon.
Exactly.
Okay. That judgment is per inquiry according to another coordinate bench.
Exactly.
And both the judgments have traveled to Supreme Court and SLP is pending.
Exactly.
Which one I will comply? Ideally speaking, I should await judgment on the Supreme Court.
No, until binding on me. My point is something different. What I want to submit before
you say rely upon one judgment, you pronounce it, I'll go to Supreme Court.
That I am saying.
But how will I ignore the other one?
Which one?
The judgment which says that same strength.
I am coming to that.
Strength is different than our.
I am coming to that. What is per inquiry? I say the judgment which says that Justice R.K. Patnaik says that he says that per inquiry. Now question comes whether it is a per inquiry or not.
I can't dissect that. I'm not sitting every over that.
I'm not saying that. I'm not saying that. What my submission is that the same order, first thing, this same order has been challenged in Supreme Court.
What you are, I understand. What you are trying to say is not very good. You are saying it is not very good. According to you, I can go into that question at all. Can I examine the shortcut order? No, says no, I can't write down whatever. No, there are two judgments available to me.
Exactly.
Both the judgment will go to Supreme Court, which is subject matter there. Not to the matter. Which one? Both the matters by Justice Panagre and Justice R. K. Patnaik has gone. Both of them not both matters. And the only option left for me is I have to wait till the Supreme Court decides. Otherwise, I had a choice of going relying upon any one judgment. The best option left for me is to rely the recent one, which is Justice Panagre. Whichever, this is Patnaik judgment. I'll say that it's period, so I'll dismiss it. My lord, but you are interested that come what may you decide it so that I will go to Supreme Court. Now, this is your situation. I understand it. I know if they lose, they will go. I understand it. But at the same time, this judgment is another problem for you. Whatever it is, I want to go. I admitted it. But when all the matters, for injury particular where from this court what is the I don't know. I don't know. I can't comment on that. That is pending before Supreme Court. And we are saying that this for injury. How can that mean? I am not examining that. I can't examine that. I am not up to that also. So what I say, my submission is, what is the immediate? Where? Very difficult. Where? Supreme Court now it's so taken. The last time we Supreme Court. You have to go and stay there for some time, so then only things will move. Yes, sir. He said that you dismiss my petition. That's what he says. So that I am happy to go there. Then find it. Find it. By suppressing the Indian cases, I read but he said that you pass either way. And I take into consideration this also. Okay. Put a note, I am reading it. Okay. Judgment reason. By Monday, Tuesday, Wednesday. 73. Yes, 73 and 74. Special mention matter. Special mention matter, my lord, is fixed yours. Which one? 64. 60? Yes, sir, 76. We are fixed to 330. Chiranjeev Nayak. 345. It's very difficult. Fixing time is very. How many matters? Let's make completely time. I am only 14 meters to control. So, 4 5. The remaining matters which are very urgent, you tell me. Simply because in any case they have to prepare.
Because 73, 74 these are same petition. It's against 138 NI Act. Power of evidence by the complainant and on after part payment by the accused, the accused has come before your lordship for passing of the cognizance on the point of law. That has to be decided.
So this will take some time, my lord.
Part payment you have made.
Yes. In two cases.
Covered by Amita Das case, my lord, where the company has not been made a party, my lord. It's to order dated 3/10/2024. Okay, then for 73, 74, huh? Yes. 73, 74. We stick up to 2 weeks. You can take order to continue. Yes. 75.
No, when your lordship.
He will give a date after 2 weeks.
Today,
no,
so sorry, I couldn't hear it. That's why
settling the dispute if you can.
I am ready, my lord, because he assured me, and out of 20 lakhs, 15,000 in one case, 10 and 5, 20,000 in another case. Total 35,000 evidence is left of the matter. Again, after the VW was issued, she appeared, went on bail and gave an undertaking before the court.
The problem, Anita Huda is creating problem for you.
Because here, check has not been issued by the company.
Okay.
That check.
Let it be this thing.
Such a case is clear.
Yes.
Check has been issued by the individual personal capacity.
Then
Made a party.
I understood it. Yes. Interim order to continue.
75.
2 weeks.
Yes.
17.
My lord,
Date may fix because
2021. No.
21 cannot my my sister's marriage.
Okay.
22nd. So
Then let it be 20. Then before or after? Before marriage, you will be. After marriage,
we come in 16th any day, 17 or 18 to the or else after 25th, my lord.
After 25th, after 25th, only.
Yes.
Finish the marriage peacefully.
My lord, after 25th.
Maybe you are 26.
26th, my lord.
26. 26. We have difficulty if we are not covered by any down like is correct.
No, that I know, my lord.
Yes.
Because of standing against prior to that, prior to issuance of check, she has also executed an agreement with me for sale of her land.
Okay. We'll see.
The only thing is that she requested to, because she was the director of the company, she wanted some money. She requested to deposit
something for 20,000. Yes.
My lord, 25, matter is pending before the third court, my lord. Matter is before mediation. So I
Awaiting mediation, when the
after 30th December, my lord. And I
to continue. Yes.
my lord, item 80.
No, 76 now. Wait.
26.
Yes. Please wait, Mr. Jana. Please wait.
Please.
80 millions on the, if lordship permits, me. Item 80, I learned from, mentioned.
It was mentioned you will do after 5 minutes. Mr. Party can finish it within 5 minutes, he says.
My lord, it is a case where the petitioner are the students who have agitated before the Board of Secondary Education about the leakage of the question paper. Then this president lost the affair and the case has been registered. It is annexure 1, page 2, 12 months.
Yes.
Then case after registration the case, some of the
opposite party
state is the one and the board minor and senior is paying for this.
Yes, sir.
Nothing is left already.
Kindly see the affair, what they have done. But they are unruly, so they have broke open the green gate. They have damaged the furniture, employees. And the students were no sympathies for us like people. In the national interest, they should be inside the jail. Rather, they are granted bail. It's only committed.
I think my land go to our petition. I am proceeding application for quashing of convenience as well further proceeding. Number one, this president himself was the APR and the president himself is the
That is all right. Get it.
So what
Secondary.
see because my
The students. They say that they are members of some ABVP. They shout, they come, they broke.
then because the papers nobody can shout. Even they can sell out the papers, nobody can shout.
Now he is like central government. Now it's right.
What is the senior that is there no sympathy
Should not be.
he may excuse anything, but what I am submitting to my lord, yes, this cross-examination has been concluded. In cross-examination, they have deputed who don't know anything. Who? After all deposed. Yes. This president himself informed by himself.
Where is the
Yes. This
they are not part of record. I don't know.
If any council is anything.
How can I only trying to give indulgence because these people are young. There may be a
that these children are what these students, if all they are students, do not deserve
these students, they are 25, 20.
We cannot be part of the system.
We can penalize them some other way, but
My friends
can't to spoil their career for some activist.
If my friend says that in giving crash examination, no evidence has come, then that will end in a how does it matter? The right evidence crossing now at this stage.
Very good, but my lord, this evidence copy I provided yesterday, but now
let him give a copy to me. Let him speak out.
let's see. I'm just reading, man. I'm just passing this hand.
Yes.
This last page. I'm just. Look at it.
So many.
Sir, I'm just reading. Consumption. From my office room, which is situated at first floor, the gate of the office was not visible. It is not a fact that no such incident took place and nobody stated.
This is what? Where is the cross? What is this?
This is last copy I'm missing. I'm just giving what.
Let him serve a copy. Let it come as an.
If this is the case,
yes,
then you will be acquitted.
Yes, it is not a question I put.
Right, man. You will target the
what I'm praying for my lord. They have employed one of the minor also. The minor is acquitted. Already been acquitted. In this trial, they acquitted by the trial court. In case of minor. Because a lot of people are there. This because involved more.
Give me so that I can get some clue. There is nothing.
Today I'm giving a note of submission as well as the paper. 2 minutes I'm giving. In that,
he made the statement.
Now GRC know the GRC amended, and now they are providing 3 copies. The same 3 copies, that's this GRC also provided that. It must be signed by a council. Otherwise, it's completely legally accepted by the. But only argument, my argument for my lord that students, those are reported that
generally with an expectation. You have shown me that the complainant has not supported the prosecution case. Therefore, I issued notice thinking that they want to force. But council of legislature is opposing the deviated. I can't cross it like that. Otherwise, he would never have done it. Unless there is some.
My lord, one second, I am just paraphrasing my lord. It is a case, two cases. One is fellow individual.
I am completely with you.
No,
subject to condition, you find the
I'm just coming.
Yes.
This is state with the state. State registered the case. Why I have made party to the board of secretary because you are the informant.
Yes.
The informant, who is the informant? The president of the board of the informant.
This is
otherwise. That's why I have some legality to my law. That's the reason I issued notice. Notice and my law direct the state council to obtain instruction also. I provide the copy, the same.
If you will change state council so frequently, what to do?
That my land of hand may not be disputed about the reputation.
About to file all the depositions and supply copy to him also tomorrow. Not tomorrow, Friday.
Thursday, either Thursday or the Monday.
Monday. Let him get. I'm giving a copy also so that
it's not better if it is Tuesday also because so that I can get the instructions.
Okay, Tuesday.
Okay, Tuesday.
Item 78 is fixed at 2 o'clock. Lordships today.
2 p.m. CG, fixing the C, he is stuck from 2 o'clock, he's waiting here. You can send someone with a password and 2 o'clock I'll take, no problem. No, it's I will be there. Yes, you can reach there. Otherwise, if not, I'll accommodate. No, I'll not fix the time, I'll accommodate. Yes, sir.
Lordship fixing.
70.
78.
78. 17. In any case, sir, they would.
Only he has to argue.
Yes, 78. Only go to. I'm just picking another date. 1 week, 46, 1 week, 2 weeks, correct? 28.
Again, lots of we'll explore those will explore the feasibility to take out at 2. We'll make a mention at 2.
No, same day you can make mention so that he will not get stuck. It's all right. 27th.
27th of November.
Yes.
Okay.
My lord,
I'm not indicating, but you just tell me that I'll take up to. Yes, yes. Yes. Yes, yes.
my lord, item 80.
1 minute, 79, Mr.
Again, I'm interrupting, my lord, sorry. I got the copy. I don't know the accused person. This is the statement.
Find those documents and give you. Yes, 79, sir.
In this time, in this situation, can we misguide the court by giving a motion?
When that ceased, there is an opposition from a respectable law, then I have to deal with.
Yes.
It's not like just for sake of it, if there is an opposition, one can overrule. But if a serious objection is there, that has to be dealt with. That has to be dealt with, therefore.
So the file in that day or who can?
That day, you place it on record, okay. Supply it. Yes, sir. I will fix a date, don't worry. Fix a date. Fix a date. Please give him some time so that he adjusts in such a manner so that the matter could be taken up. Not that every matter is listed when it can't be taken up for his use. Let him. I know that is the whole difficulty. Please give him some time so that he can adjust accordingly. Yes. Yes, Mr. Jana.
Yes, item 80. I'm the last item. I understand the heavy board, your lordships, but my client is without pension for a long time.
When can just see when can
next Monday, your lordship.
Monday, I don't think Monday will be possible. Again, the same thing will happen.
If a lordship can accommodate because I am there already in the Sunday, lordship.
Till 22nd, there is no space. Let it be
either of 15, your lordship. Monday suits me, your lordship.
30, that is working. 30 and 7, both are working.
Why don't we do it on 30 or because 30 is working day because
13 is okay.
13 no, 13 Saturday. Nobody would be there. You come and argue.
Your lordship, then it is Monday. Your lordship, Monday, I will take a chance in Monday.
Keep it to some Monday, yeah.
Monday, that is 11, your lordship.
11 it won't happen. Unnecessary you will wait.
Next one, next one, item 77. My line from Mr. Panda eagerly waits for his case to be taken up. Let's go back to date memory.
Give me, except December Millards, a little.
We're traveling, I know that.
No, I have to attend a marriage of a close relation. So 4 or 5 days.
Odisha, outside Odisha.
No, he doesn't attend marriages in Odisha. He goes abroad only. Must be some USA or somewhere he go.
Maybe a surreptitious.
And it is not a secret also, you will come to know. You know the sources. Yes.
Whenever he goes outside, he brings something for me. So I know, so you have to know what he's going to say.
I can't make that hope, but yes. When November last week of November. Yes.
Yes.
So 79,
And that interim
agreement has been adjourned.
The interim agreement continue. Yes.
Lordship has adjourned to some other day.
Which one?
79, in all the three appeals, I pray before your Lordship that name may be, my name may kindly.
Name reflects, no?
In all the three appeals.
Yes, yes. Anything?
Instead of Srimanta Das.
His, instead of
Srimanta Das may
number,
be deleted, my name may be.
Sanjay Das. Not deleted, let him be also bear with you. Complete.
Maybe.
Along with you. Okay.
My lordship, there Monday, also lordship, given me Monday.
He said that on the date fixed, the application for adjournment will be.
Yes, 77 the same photo. Date fix, repeat the application. Repeat the application for project.
Lordship granted me Monday, your lordship.
I will give a date.
Please, lordship, deeply obliged.